Business and Law for Michigan Residential Builder Licenses. Welcome to AYPO's Michigan Residential Builder Training Course. This course provides 60 hours of training, which will consist largely of information pertaining to construction laws, business practices, and building codes in Michigan and various municipalities. A final exam with multiple choice questions will conclude the training, with a score of 70% or higher required to pass. Once you complete this course, you will be eligible to receive your Michigan Contractor Certification. This course will follow the guidelines from the state and cover all the required topics in order: business management, estimating, and job costing, design and building science, contracts, liability, and risk management, marketing and sales, project management and scheduling, the Michigan Residential Code, MIOSHA Construction Safety Standards. Before we dive into the topic of business management, we'll briefly cover the requirements of licensure. It wouldn't hurt to be informed on the process of contractor licensure in Michigan. We will see who needs to be licensed, the agency that licenses builders, and what needs to be accomplished to earn that license. Actions requiring license. All contractors offering to perform any construction, alteration, or repair work that totals $600 or more in labor and materials must be licensed by the Department of Licensing and Regulatory Affairs, LARA. There are 3 levels of licensure offered. A residential builder's license allows a contractor to build a complete residential structure and to do maintenance and alteration, remodeling, work on a residential structure. A maintenance and alteration (M&A) license indicates that the holder has met requirements for one or more of the following trades: basement waterproofing, carpentry, concrete, excavation, house wrecking, insulation, masonry, painting and decorating, roofing, screen and storm sash, gutters, siding, swimming pools, tile and marble. The trades for which a maintenance and alteration contractor is qualified to practice are listed on the M&A license. A salesperson license is required of those who deal with the public on behalf of a building licensee. In addition, each branch office, i.e., shop, out of which a licensee operates must be licensed. A branch office is any business address used by a licensed residential builder or maintenance and alteration contractor. If a residential builder or M&A contractor is operating out of more than one location, the second location must be licensed as a branch office. A licensed residential builder or maintenance and alteration contractor may obtain a branch office license application on the LARA website under Forms. The application must be completed and submitted to the department, along with the application fee. Residential builder and M&A contractor. Source: Flickr. Beginning June 1, 2008, an applicant for an initial residential builder or maintenance and alteration contractor license must successfully complete 60 hours of approved pre-licensure education prior to taking the examination or submitting a license application to the department unless he or she is exempt from the pre-licensure course of study per MCL 339.2404b as outlined below. If an individual who holds a residential builder or a residential maintenance and alteration contractor license, or an individual who held a license as a qualifying officer of a licensed residential builder or residential maintenance and alteration contractor, on June 1, 2008 is renewing a license, he or she is exempt from the requirement of successfully completing the required pre-licensure courses. B. If an individual is applying for a license or relic insure as a residential builder or residential maintenance and alteration contractor, he or she is exempt from the requirement of successfully completing pre-licensure courses if all of the following are met. 1. His or her application is submitted before the expiration of the 18-month period beginning on the effective date of the Amendatory Act that added this subsection. This subdivision does not apply to applications that are submitted after the 18-month period. 2. He or she held an individual license as a residential builder or residential maintenance and alteration contractor, or held a license as a qualifying officer of a licensed residential builder or residential maintenance and alteration contractor, at any time within the 9-year period preceding his or her application. Education. All pre-licensure education courses for residential builder and M&A contractor licenses must be approved by the department. The 60 hours of approved pre-licensure courses must include at least 6 hours in each of the following subjects. 1. Business management, estimating, and job costing. 2. Design and building science. 3. Contracts, liability, and risk management. 4. Marketing and sales. 5. Project management and scheduling. 6. The Michigan Residential Code. 7. MIOSHA construction safety standards, and 8. The rest of the 18 hours may come from other topics on the approved course list. After an applicant has completed the 60-hour pre-licensure education requirement, he or she may apply online or obtain an individual residential builder and maintenance and alteration contractor license application on the LARA Bureau of Construction Codes website, under Licensing, Examinations and Continuing Education. The license application must be completed and submitted with the application fee. Testing. Once the licensing division receives an application, it will be reviewed to ensure that the applicant meets all licensing requirements. The requirements for licensure include 60 hours of approved pre-licensure education courses. Be of good moral character. Submit any required documentation requested by the department, and pass the required examination. An applicant must meet all requirements for licensure before receiving approval by the department to take the examination that is required to obtain a residential builder or maintenance and alteration contractor license. Once the applicant receives an authorization to test (ATT) letter, he or she may contact PSI Services LLC, the exam provider, at 800-733-9267, or go to the website at www.sciexams.com to register for the examination. After the applicant passes both portions of the examination, a license will be issued as an individual residential builder or individual maintenance and alteration contractor. The individual license will allow an individual to perform work as a sole proprietor, under their personal name or an assumed name, which is also called DBA, or doing business as, such as Bob the Builder, from their county clerk's office. The individual license may not be used for a corporation, limited liability company, or partnership. If you are conducting business as a corporation, limited liability company, or partnership, you must also apply for a second license, which will be for the business entity. You may obtain a corporation, limited liability company, or partnership residential builder and maintenance and alteration contractor license application on the LARA website under Forms. Salesperson. Applicants for the residential builder or maintenance and alteration contractor salesperson license must be of good moral character, must be employed by a licensed residential builder or maintenance and alteration contractor, and successfully pass an examination. It is illegal to accept a contract procured by a salesperson not licensed under a builder or contractor, unless it is for the sale of real estate through a licensed broker. Salesperson applicants must contact PSI Services LLC at 800-733-9267 or visit their website at www.sciexams.com to register for the examination. Once an applicant has passed the salesperson examination, the applicant may apply online or may complete and submit the salesperson license application to the licensing division, along with the required application fee. Note: an individual who is currently licensed as a builder or M&A contractor, or who has been actively licensed in the past 3 years, can be licensed as a salesperson in the employ of another builder or M&A contractor, employee or independent contractor, without taking the salesperson's examination. An individual may have only one license as a salesperson. Renewals. All 4 types of licenses, residential builder, M&A contractor, salesperson, and branch office, expire on May 31st of the 3rd year after they are issued. Residential builders and M&A contractors must show evidence of 3 hours of continuing education in required topics during the 3-year cycle in order to have a license renewed. Michigan no longer accepts renewals by mail. Licenses can only be renewed online. Display of licenses. In order to enforce the license laws described above, Michigan requires that a state license must be displayed in the place of business, customarily hung on the wall with or without a frame. In addition, all contractors and their salespersons must carry a pocket card, which LARA advises that all consumers request to see prior to hiring for their home, building, or improvement project. LARA also encourages those who suspect that unauthorized building is being performed to check whether the builder and/or salesperson is currently licensed on the Check a License link on the LARA website. How to follow up. To access the State of Michigan's LARA website, click here. From there, you can get more information about getting a contractor's license, renewing your license, look up a licensee, file a complaint, and more. There is also a helpful list of answers to frequently asked questions on general licensing issues. A. Residential builder. Residential builder means a person engaged in the construction of a residential structure or a combination residential and commercial structure who, for a fixed sum, price, fee, percentage, valuable consideration, or other compensation, other than wages for personal labor only, undertakes with another or offers to undertake or purports to have the capacity to undertake with another for the erection, construction, replacement, repair, alteration, or in addition to, subtraction from, improvement, wrecking of, or demolition of, a residential structure or combination residential and commercial structure, a person who manufactures, assembles, constructs, deals in, or distributes a residential or combination residential and commercial structure which is prefabricated, pre-assembled, pre-cut, packaged, or shell housing, or a person who erects a residential structure or combination residential and commercial structure except for the person's own use and occupancy on the person's property. B. Residential maintenance and alteration contractor. Residential maintenance and alteration contractor means a person who, for a fixed sum, price, fee, percentage, valuable consideration, or other compensation, other than wages for personal labor only, undertakes with another for the repair, alteration, or in addition to, subtraction from, improvement of, wrecking of, or demolition of a residential structure or combination residential and commercial structure, or building of a garage, or laying of concrete on residential property, or who engages in the purchase, substantial rehabilitation or improvement, and resale of a residential structure, engaging in that activity on the same structure more than twice in one calendar year, except in the following instances. 1. If the work is for the person's own use and occupancy. 2. If the rehabilitation or improvement work of residential type property or a structure is contracted for, with, or hired entirely to be done and performed for the owner by a person licensed under this article. 3. If work is performed by a person employed by the owner to perform work for which the person is licensed by the state. C. Residential structure. Residential structure means a premises used or intended to be used for a residence purpose and related facilities appurtenant to the premises, used or intended to be used, as an adjunct of residential occupancy. D. Salesperson. Salesperson means an employee or agent, other than a qualifying officer, of a licensed residential builder or residential maintenance and alteration contractor who for a salary, wage, fee, percentage, commission, or other consideration, sells or attempts to sell, negotiates or attempts to negotiate, solicits for or attempts to solicit for, obtains or attempts to obtain a contract or commitment for, or furnishes or attempts or agrees to furnish, the goods and services of a residential builder or residential maintenance and alteration contractor, except a person working for a licensed residential builder or residential maintenance and alteration contractor who makes sales which are occasional and incidental to the person's principal employment. E. Wages. Wages means money paid or to be paid on an hourly or daily basis by an owner, lessor, or occupant of a residential structure or combination residential and commercial structure as consideration for the performance of personal labor on the structure by a person who does not perform or promise to perform the labor for any other fixed sum, price, fee, percentage, valuable consideration, or other compensation and who does not furnish or agree to furnish the material or supplies required to be used in the performance of the labor or an act defined in subdivision A or B. 339.2402. Section 339.2402 Residential Builders and Maintenance and Alteration Contractors Board, Creation, Qualifications of Members. A Residential Builders and Maintenance and Alteration Contractors Board is created. Of the 9-member board, 4 members shall be licensed residential builders, and 2 members shall be licensed maintenance and alteration contractors. Of the members representing the general public, at least 1 member shall be registered under the Building Officials and Inspectors Registration Act, 1986 PA 54, MCL 338.2301 to 338.2313. 339.2403. Section 339.2403 Engaging in business or acting in capacity of residential builder or residential maintenance and alteration contractor or salesperson without license. Notwithstanding Article 6, a person may engage in the business of or act in the capacity of a residential builder or a residential maintenance and alteration contractor or salesperson in this state without having a license, if the person is one of the following. F. An authorized representative of the United States government, this state, or a county, township, city, village, or other political subdivision of this state. B. An owner of property, with reference to a structure on the property for the owner's own use and occupancy. C. An owner of rental property, with reference to the maintenance and alteration of that rental property. D. An officer of a court acting within the terms of the officer's office. E. A person other than the salesperson who engages solely in the business of performing work and services under contract with a residential builder or a residential maintenance and alteration contractor licensed under this article. F. A person working on one undertaking or project by one or more contracts, the aggregate contract price for which labor, material, and any other item is less than $600. This exemption does not apply if the work of a construction is only a part of a larger or major operation, whether undertaken by the same or a different residential builder or residential maintenance and alteration contractor, or in which a division of the operation is made in contracts of amounts less than $600, to evade this act. G. An electrical contractor who was licensed under Act No. 217 of the Public Acts of 1956, as amended, being sections 338.881 to 338.892 of the Michigan compiled laws. This exemption applies only to the electrical installation, electrical maintenance, or electrical repair work performed by the electrical contractor. H. A plumbing contractor licensed under Act No. 266 of the Public Acts of 1929, as amended, being sections 338.901 to 338.917 of the Michigan compiled laws. This exemption applies only to plumbing installation, plumbing maintenance, or plumbing repair work performed by the plumbing contractor. 1. A mechanical contractor who is licensed under the Mechanical Contractors Act. This exemption applies only to mechanical installation, mechanical maintenance, or mechanical repair work performed by the mechanical contractor. 339.2404. Section 339.2404 for evidence of good moral character, proof of identity, examination, issuance of residential maintenance and alteration contractor's license, scope of crafts and trades, place of business, branch office license, duration of license, renewal, documentation of continuing competency requirements. 1. Except as provided in Section 2404C, the Department may require an applicant, a licensee, or each partner, trustee, director, officer, member, or shareholder of an applicant or licensee to submit evidence of good moral character. Before the Department issues a license, an applicant shall submit a copy of his or her operator's license or state personal identification card to the Department. The Department may use the license or card only for proof of identity of the applicant. 2. Except as provided in Section 2404C, the Department shall require that an applicant for a license under this article pass an examination that establishes that the applicant has a fair knowledge of the obligations of a residential builder or residential maintenance and alteration contractor to the public and the applicant's principal, and the statutes relating to the applicant's licensure. 3. Except as provided in Section 2404C, the Department may issue a residential maintenance and alteration contractor's license to an individual who applies for the license and who qualifies for the license by passing the examination. A license authorizes the licensee, according to the applicant's qualifications, crafts, and trades, to engage in the activities of a residential maintenance and alteration contractor. A license includes the following crafts and trades: carpentry, concrete, swimming pool installation, waterproofing abasement, excavation, insulation work, masonry work, roofing, siding and gutters, screen or storm sash installation, tile and marble work, and house wrecking. A license shall specify the particular craft or trade for which the licensee is qualified. This subsection does not prohibit a specialty contractor from taking and executing a contract involving the performance of the craft or trade for which the contractor holds a license in one or more other crafts or trades if the performance of the work in the other craft or trade is incidental and supplemental to the performance of work in the craft or trade for which the specialty contractor is licensed. 4. A residential builder or residential maintenance and alteration contractor shall maintain a place of business in this state. If a residential builder or residential maintenance and alteration contractor maintains more than one place of business in this state, the Department shall issue a branch office license to the builder or contractor for each place of business maintained by the builder or contractor. 5. The Department shall issue the license of a residential builder and residential maintenance and alteration contractor for a period of 3 years in duration. 6. An applicant for renewal of a residential builder or maintenance and alteration contractor license shall state to the Department that he or she has a current copy of the Michigan Residential Code and meets the appropriate requirements regarding continuing competency described in this article or rules promulgated under this article. 7. A licensee shall maintain documentation, for at least 5 years, of activities that meet the continuing competency requirements under this article. Sections 339.2404A, 2404B, 2404C, and 2405. Click Next Page to continue. 339.2404A Information to be provided as part of contract. A licensee shall, as part of the contract, provide information relating to his or her individual license and to any license issued to that person as a qualifying officer of another entity. 339.2404b. Section 339.2404b Licensure as residential builder or residential maintenance and alteration contractor, completion of pre-licensure course of study, disciplinary action, continuing competency requirements, approved courses, subject matter, rules, alternate forms of continuing competency, department audit, application for inactive status, designation of licensee as inactive, exemption from requirements in subsection 1, affidavit signed by commanding officer, supervisor, or military superior, retaking. Examination 1. Beginning June 1, 2008, an applicant for initial licensure either as a residential builder or as a residential maintenance and alteration contractor must successfully complete the pre-licensure course of study requirements under this subsection to obtain a license unless he or she is exempt from those requirements under this section. All of the following apply for purposes of this subsection. If an individual who holds a residential builder or a residential maintenance and alteration contractor license, or an individual who held a license as a qualifying officer of a licensed residential builder or residential maintenance and alteration contractor, on June 1, 2008 is renewing a license, he or she is exempt from the requirement of successfully completing pre-licensure courses described in this subsection. B. If an individual is applying for a license or relic insure as a residential builder or residential maintenance and alteration contractor, he or she is exempt from the requirement of successfully completing pre-licensure courses described in this subsection if all of the following are met. 1. His or her application is submitted before the expiration of the 18-month period beginning on September 16, 2014. This subdivision does not apply to applications that are submitted after that 18-month period. 2. He or she held an individual license as a residential builder or residential maintenance and alteration contractor, or held a license as a qualifying officer of a licensed residential builder or residential maintenance and alteration contractor, at any time within the 9-year period preceding his or her application. C. Unless he or she is exempt under subdivision A, or B, an applicant must not receive an initial license under this Act unless he or she successfully completed 60 hours of approved pre-licensure courses that include at least 6 hours of courses in each of the following areas of competency: 1. Business management, estimating, and job costing. 2. Design and building science. 3. Contracts, liability, and risk management. 4. Marketing and sales. 5. Project management and scheduling. 6. The current Michigan Residential Code. 7. Construction safety standards promulgated under the Michigan Occupational Safety and Health Act, 1974 PA 154, MCL 408.1001 to 408.1094. 2. All of the following apply to an individual license under this article, as applicable. A. Subject to subdivision. B. If the individual licensee obtained his or her initial license as a residential builder or a residential maintenance and alteration contractor on or after January 1, 2009, he or she must successfully complete at least 21 hours of activities that demonstrate continuing competence in each 3-year license cycle, including both of the following. 1. At least 3 hours of activities that demonstrate continuing competency in each calendar year, during the first 6 calendar years of licensure. 2. At least 3 hours of activities designed to develop a licensee's understanding and ability to apply state building codes and laws relating to the licensed occupation, safety, and changes in construction and business management laws. B. If an individual licensee described in subdivision A was exempt from the pre-licensure course requiring 339.2404 be continued. 5. The subject matter of the pre-licensure and continuing competency activities required under this section may be offered by a high school, an intermediate school district, a community college, a university, the Bureau of Construction Codes, the Michigan Occupational Safety and Health Administration, a trade association, or any other proprietary school that is licensed by the department. 6. The department shall promulgate rules to provide for the following. Requirements other than those listed in subsection 4, for determining that a course meets the minimum criteria for developing and maintaining continuing competency. B. Requirements for acceptable courses offered at seminars and conventions by trade associations, research institutes, risk management entities, manufacturers, suppliers, governmental agencies other than those named in subsection 4, consulting agencies, or other entities. C. Acceptable distance learning. D. Alternate forms of continuing competency, including comprehensive testing, participation in mentoring programs, research, participation in code hearings conducted by the International Code Council, and publication of articles in trade journals or regional magazines as an expert in the field. The alternate forms must be designed to maintain and improve the licensee's ability to perform the occupation with competence and must prescribe proofs that are necessary to demonstrate that the licensee has fulfilled the requirements of continuing competency. 7. Each licensee may select approved courses in his or her subject matter area or specialty. A licensee's service as a lecturer or discussion leader in an approved course must count toward his or her continuing competency requirements under this section. Alternate forms of continuing competency may be earned and documented as promulgated in rules by the department. 8. The department may audit a predetermined percentage of licensees who renew in a year for compliance with the requirements of this section. Failure to comply with the audit or the requirements results in the investigation of a complaint initiated by the department, and the licensee is subject to the penalties prescribed in this Act. 9. Before September 16, 2014, a licensed residential builder or residential alteration and maintenance contractor may apply for inactive status by completing an application, made available by the department, in which he or she declares that he or she is no longer actively engaged in the practice authorized by his or her license and temporarily intends to suspend activity authorized by his or her license. If a completed application is submitted, the department shall designate the licensee as inactive and note that status on records available to the public. A licensee who is designated as inactive must have a current copy of the Michigan Residential Code and is exempt from the continuing competency requirements imposed under this section, but must still pay the per-year license fee. An inactive licensee may activate his or her license by submitting an application to the department requesting activation of the license. If the department activates an inactive license, the licensee must complete at least 1 credit hour of activities that demonstrate continuing competency for that calendar year. 339.2404 be continued. 10. An individual licensee who applied for and was designated inactive under subsection 9 before September 16, 2014 may remain in inactive status after that date by complying with the requirements of subsection 9. A licensee who remains in inactive status after September 16, 2014 is exempt from the continuing competency requirements of this section while he or she remains in inactive status. A licensee may activate his or her license by submitting an application to the department requesting activation of the license. If his or her license is activated, the licensee must complete at least 1 credit hour of activities that demonstrate continuing competency for that calendar year. 11. Subject to subsection 13, an applicant for initial licensure as a residential builder or residential maintenance and alteration contractor is exempt from the requirements of subsection 1 if he or she meets all of the following. A. Served in the armed forces. B. While serving in the armed forces, was engaged in the erection, construction, replacement, repair, alteration, or demolition of buildings or other structures. C. Was separated from service in the armed forces, and provides to the department a Form DD-214, Form DD-215, or any other form that is satisfactory to the department that demonstrates that he or she was separated from that service, with an honorable character of service or under honorable conditions, general character of service. D. Has, and provides with his or her application an affidavit signed by a commanding officer, supervisor, or military superior with direct knowledge of the applicant's service that he or she has entry-level experience in or basic knowledge of each of the areas of competency described in subsection 1c. 12. If an applicant who otherwise meets the requirements of subsection 11 does not have entry-level experience in or basic knowledge of each of the areas of competency described in subsection 1c, he or she may provide with his or her application an affidavit signed by a commanding officer, supervisor, or military superior with direct knowledge of the applicant's service that states in which of those areas of competency the applicant has entry-level experience or basic knowledge, and the department may in its discretion grant the applicant credit toward the 60-hour pre-licensure education requirement of subsection 1, based on that experience or knowledge. 13. If an applicant for initial licensure as a residential builder or residential maintenance and alteration contractor described in subsection 11 does not pass the examination for that license the first time he or she takes the examination, that applicant may not retake the examination until he or she successfully completes a pre-licensure course of study described in subsection 1. 339.2404c Individual denied license because of financial instability. All of the following apply to an individual who is applying for a license or relic insure as a residential builder or residential maintenance and alteration contractor, who was a qualifying officer on December 21, 2007, and who was subsequently denied an individual license because of financial instability. The department shall determine whether the applicant should receive a license under this article and what requirements described in Section 24.0 for the applicant must meet to qualify for that license. B. In making its determination under subdivision A, the department shall consider the information it receives under Section 2404(1) concerning the good moral character of the applicant and other persons described in Section 2404(1), shall determine whether the applicant is required to pass an examination under Section 2404(2) or 3 or 2405(1), and may require that the applicant meet other requirements to qualify for a license. C. The applicant shall certify that he or she successfully completed at least 3 hours of activities that demonstrate continuing competency, that include 1 hour of codes, 1 hour of safety, and 1 hour of legal issues described in Section 2404(b)(2) in the 12 months immediately preceding the date of application. 339.2405. Section 2405. Application for license by corporation, partnership, association, limited liability company, or other entity, designation and responsibilities of qualifying officer, age and license requirements, suspension, revocation, or denial of license. If a license is applied for by a corporation, partnership, association, limited liability company, or other entity, the applicant shall designate one of its officers, partners, members, or managing agent as a qualifying officer who, upon taking and passing the examination, and upon meeting all other requirements of this article, is entitled to a license to act for the corporation, partnership, association, limited liability company, or other entity. The qualifying officer shall also obtain and maintain a license under this article as an individual. The qualifying officer shall be responsible for exercising the supervision or control of the building or construction operations necessary to secure full compliance with this article and the rules promulgated under this article. A license shall not be issued to a corporation, partnership, association, limited liability company, or other entity unless each partner, trustee, director, officer, member, and a person exercising control is at least 18 years of age and meets the requirements for a license under this article other than those relating to knowledge and experience. If an individual licensee is also a qualifying officer, the individual's name and license number shall be listed on any license issued to the individual as a qualifying officer. In the case of a license issued under this subsection, each officer, partner, member, or managing agent, whether or not he or she is the qualifying officer, shall provide a copy of his or her operator's license or state personal identification card to the department for use by the department only for identification purposes. A licensee granted inactive status under Section 2404(b) is not eligible to serve as a qualifying officer. The license of a corporation, partnership, association, limited liability company, or other entity shall be suspended when a license or license application of a qualifying officer, partner, trustee, director, officer, member, or a person exercising control of the corporation, partnership, association, limited liability company, or other entity is suspended, revoked, or denied. The suspension shall remain in force until the board determines that the disability created by the suspension, revocation, or denial has been removed. A suspension, revocation, or denial of a license of an individual shall suspend, revoke, or deny any other license held or applied for by that individual issued under this article. A suspension, revocation, or denial of a license by the department shall suspend, revoke, or deny any other license held or applied for under this article by the qualifying officer of a corporation, partnership, association, limited liability company, or other entity whose license is suspended, revoked, or denied. If the qualifying officer of a licensee ceases to be its qualifying officer, the license is suspended. However, upon request, the department may permit the license to remain in force for a reasonable time to permit the qualification of a new qualifying officer. 339.2406. Section 2406. Non-resident licensee, issuing license to foreign corporation, irrevocable consent to service of process, resolution authorizing consent, service of process or pleading. A non-resident of this state may become a licensee under this article by conforming with this article. A license shall not be issued to a foreign corporation unless the corporation is authorized to do business in this state by the Corporation and Securities Commission. The non-resident shall file an irrevocable consent to service of process. The consent shall be signed by the applicant or by an authorized officer, member, or partner of the applicant and shall be notarized. If the applicant is a corporation, consent shall be accompanied by a certified copy of the resolution of the corporation authorizing the consent. A process or pleading served upon the department shall be sufficient service upon the licensee. A process or pleading served upon the department under this section shall be in duplicate. The department immediately shall forward by registered mail one copy of the process or pleading to the main office of the licensee served. 339.2407. Section 2407. Licensing salesperson in employ of one builder or contractor, application for transfer and issuance of new license, submission of salesperson's license application. A salesperson shall be licensed in the employ of only one residential builder or maintenance and alteration contractor. If a salesperson desires to change employment from one residential builder or maintenance and alteration contractor to another, the license shall be forwarded to the department and application made for a transfer and the issuance of a new license under the salesperson's new employer. An application for a salesperson's license shall be submitted by the employing residential builder or residential maintenance and alteration contractor. 339.2409. Section 2409. Reporting certain changes. A licensee shall report to the department a change of name or address or a change of members or addresses of the partnership, association, or corporation holding a license under this article within 30 days after the change occurs. 339.2410. Section 2410. Repeating examination not required when making application for additional license. A person or qualifying officer for a corporation or member of a partnership or other business association who currently holds a residential builder or maintenance and alteration contractor license shall not be required to repeat an examination for that license when making application for an additional license. However, a maintenance and alteration contractor who currently holds a license and makes application for a residential builder's license shall be required to take an examination for that license. 339.2411. Section 2411. Complaint, conduct subject to penalty, violations, review, administrative proceedings regarding workmanship, order of default, verified complaint defined. A complaint filed under this section or Article 5, or both, shall be made within 18 months after the latest of the following regarding a residential structure or a combination of residential and commercial structure as follows. A. In the case of a maintenance and alteration contract, 1. Completion. 2. Occupancy. 3. Purchase. B. In the case of a project requiring an occupancy permit, 1. Issuance of the certificate of occupancy or temporary certificate of occupancy. 2. Closing. A licensee or applicant who commits one or more of the following is subject to the penalties set forth in Article 6. A. Abandonment without legal excuse of a contract, construction project, or operation engaged in or undertaken by the licensee. B. Diversion of funds or property received for prosecution or completion of a specific construction project or operation, or for a specified purpose in the prosecution or completion of a construction project or operation, and the funds or property application or use for any other construction project or operation, obligation, or purposes. C. Failure to account for or remit money coming into the person's possession that belongs to others. D. A willful departure from or disregard of plans or specifications in a material respect and prejudicial to another, without consent of the owner or an authorized representative and without the consent of the person entitled to have the particular construction project or operation completed in accordance with the plans and specifications. E. A willful violation of the building laws of this state or of a political subdivision of this state. F. In a residential maintenance and alteration contract, failure to furnish to a lender the purchaser's signed completion certificate executed upon completion of the work to be performed under the contract. G. If a licensed residential builder or licensed residential maintenance and alteration contractor, failure to notify the department within 10 days of a change in the control or direction of the business of the licensee resulting from a change in the licensee's partners, directors, officers, or trustees, or a change in the control or direction of the business of the licensee resulting from any other occurrence or event. H. Failure to deliver to the purchaser the entire agreement of the parties including any finance or other charge arising out of or incidental to the agreement if the agreement involves repair, alteration, or addition to, subtraction from, improvement of, wrecking of, or demolition of a residential structure or combination of residential and commercial structure, building of a garage, laying of concrete on residential property, or manufacture, assembly, construction, sale, or distribution of a residential or combination residential and commercial structure that is prefabricated, pre-assembled, pre-cut, packaged, or shell housing. 1. If a salesperson, failure to pay over immediately upon receipt money received by the salesperson, in connection with a transaction governed by this article to the residential builder or residential maintenance and alteration contractor under whom the salesperson is licensed. J. Aiding or abetting an unlicensed person to evade this article, or knowingly combining or conspiring with, or acting as agent, partner, or associate for an unlicensed person, allowing one's license to be used by an unlicensed person, or acting as or being an ostensible licensed residential builder or licensed residential maintenance and alteration contractor for an undisclosed person who does or shall control or direct, or who may have the right to cont. 339.2411, continued. The Department shall conduct a review upon notice that the licensee has violated the Asbestos Abatement Contractors Licensing Act, 1986 PA 135, MCL 338.3101 to 338.3319. The Department may suspend or revoke that person's license for a knowing violation of the Asbestos Abatement Contractors Licensing Act, 1986 PA 135, MCL 338.3101 to 338.3319. Notwithstanding Article 5, the following apply to administrative proceedings regarding workmanship under subsection 2(m). A complaint submitted by an owner shall describe in writing to the Department the factual basis for the allegation. The homeowner shall send a copy of the initial complaint to the licensee concurrent with the submission of the complaint to the Department. B. The Department shall presume the innocence of the licensee throughout the proceeding until the administrative law hearing examiner finds otherwise in a determination of findings of fact and conclusions of law under Article 5. The licensee has the burden of refuting evidence submitted by a person during the administrative hearing. The licensee also has the burden of proof regarding the reason deficiencies were not corrected. C. Upon receipt of a building inspection report issued to the Department by a state or local building enforcement official authorized to do so under the Stilda-Rossett-Hale Single State Construction Code Act, 1972 PA 230, MCL 125.1501 to 125.1531, which report verifies or confirms the substance of the complaint, the Department shall send by certified mail a copy of the verified complaint to the licensee. If the Department does not send a copy of the verified complaint within 30 days after receipt of the building inspection report, the Department shall not assess a fine against the licensee under Article 6, but the Department may pursue restitution, license suspension, or other remedies provided under this Act. D. A licensee may contractually provide for an alternative dispute resolution procedure to resolve complaints filed with the Department. The procedure shall be conducted by a neutral third party for determining the rights and responsibilities of the parties and shall be initiated by the licensee, who shall provide notice of the initiation of the procedure to the complainant by certified mail not less than 30 days before the commencement of that procedure. The procedure shall be conducted at a location mutually agreed to by the parties. E. The Department shall not initiate a proceeding against a licensee under this subsection if the licensee has contractually provided for an alternative dispute resolution procedure that has not been utilized and completed unless it is determined that the licensee has not complied with a decision or order issued as a result of that alternative dispute resolution procedure. That alternative dispute resolution procedure was not fully completed within 90 days after the filing of the complaint with the Department, or an alternative dispute resolution procedure meeting the requirements of subdivision D is not available to the complainant. F. The complainant shall demonstrate that notice has been provided to the licensee describing reasonable times and dates that the residential structure was accessible for any needed repairs and proof acceptable to the Department that the repairs were not made within 60 days after the sending of the notice. This subdivision does not apply if the Department determines a necessity to safeguard the structure or to protect the occupant's health and safety and, in such case, the Department may utilize any remedy available under Section 504(3). G. If the owner and licensee have agreed contractually on mutually acceptable performance guidelines relating to workmanship, the Department shall consider those guidelines in its evaluation of a complaint. The guidelines shall be consistent with the Stillderosset-Hale Single State Construction Code Act, 1972 PA 230, MCL 125.1501 to 125.1531. If the licensee or respondent fails to appear or participate in or defend any action, the board shall issue an order granting by default the relief requested, based upon proofs submitted to and findings made by the hearing examiner after a contested case. 339.2411a. Section 2411a. Final Order of Board, Posting on Website. The Department shall post on its website any final order of the Board and the date it was issued. The posting shall occur within 30 days after the final order is issued. The Department shall annually post on its website the number of final orders of the Board. 339.2412. Section 2412. Action for collection of compensation for performance of act or contract, alleging and proving licensure, failure to use alternative dispute resolution, other legal action, civil violation. A person or qualifying officer for a corporation or member of a residential builder or residential maintenance and alteration contractor shall not bring or maintain an action in a court of this state for the collection of compensation for the performance of an act or contract for which a license is required by this article without alleging and proving that the person was licensed under this article during the performance of the act or contract. Failure of the person bringing a complaint against a licensee to utilize a contractually provided alternative dispute resolution procedure shall be an affirmative defense to an action brought in a court of this state against a licensee under this article. A person or qualifying officer for a corporation or a member of a residential builder or residential maintenance and alteration contractor shall not impose or take any legal or other action to impose a lien on real property unless that person was licensed under this article during the performance of the act or contract. A prosecuting attorney and the Attorney General may bring an action for a civil violation in a court of competent jurisdiction against a person not licensed under this article that has violated Section 601, 1, or 2. The court shall assess a civil fine, to be paid to the prosecuting attorney or the Attorney General bringing the action, of not less than $5,000 and not more than $25,000, aside from any civil damages or restitution. Business Startup Checklist. Source: Public Domain Pictures. 1. Select a name and a legal structure. 2. Write a business plan. 3. Obtain your FINE, Federal Employee Identification Number, if applicable. 4. Open the company bank account. 5. Obtain financing. 6. Lease office/warehouse/retail space. 7. Obtain licenses and permits. 8. Set up an accounting and record-keeping system. 9. Obtain business insurance. 10. Develop a business identity. 11. Systematize and organize. 12. Hire employees, if applicable. 13. Get the word out. Select a name and a legal structure. Click Next page to continue. Choosing a name. Choosing a name for your business should not be taken lightly. Your business name can have a dramatic impact on how your company is perceived, affecting your business in every aspect. Some things to consider when choosing a name. Make it unique and memorable. Choose a name that can survive the growth of your company. For example, a company opened in the 80s, named Bob's VCR Repair, would be out of date in today's age of video streaming, Blu-ray players, and home movies filmed on cell phones. Make sure the name is easy to understand and remember. Sole proprietor. This is a business owned and operated by a single individual, but may also include the owner's spouse. There are no partners in the business, and the sole proprietor makes all decisions regarding operations of the business. The business does not pay income tax. Instead, the owner pays individual income taxes on any profits from the business. Benefits to a sole proprietorship. Easy to create. Fewer regulations to follow and fewer forms to file. The owner, contractor, makes all business decisions. Eligible to establish a deductible KEO plan, a tax-deferred pension plan, for retirement. Healthcare costs are deductible. Drawbacks to a sole proprietorship. Unlimited personal liability. Business license ceases upon death of owner. All financing comes from owner's personal assets or credit. Profits are taxed as individual income. Self-employment taxes are based on net income. Partnership. Source: PX here. Partnerships are businesses owned and operated by two or more individuals. They may be general partnerships, in which both parties have equal investment and equal say in the operations of the business, or they may be limited partnerships, in which one partner, the general partner, is responsible for the day-to-day operations and decisions of the business and the other partners is a silent partner who supplies only financial investment. The business does not pay income tax, instead, the partners pay individual income taxes on any profits from the business. Benefits to a partnership: greater financial resources, greater pools of talent for the business to draw on. Daily operational responsibilities can be shared. Profits of the partnership are only taxed once. Business losses can be used to offset other taxable income. Drawbacks to a partnership: each partner has unlimited liability for all debts. The partnership ends with the death, bankruptcy, or withdrawal of any partner. No partnership interest can be transferred without the consent of all the partners. A general partnership must pay self-employment taxes. Benefits to an LLC: partners have limited liability for acts of the company. Partners have no liability for obligations or debts incurred by individual members. Taxes are assessed only on income distributed to partners, not company gross or net profit. Partners can take a distribution rather than a salary, reducing employment taxes. All other benefits of standard partnerships apply. Drawbacks to an LLC: an LLC can be more expensive and complicated to create than a partnership. LLCs require more record-keeping and have greater reporting and disclosure requirements than partnerships. Tax filings for LLC companies can be very complicated. The LLC may not sign contracts, but must designate an agent authority which is responsible for entering agreements for the LLC. Corporation. A corporation is a legal structure which separates investors, called shareholders, from the operations of a business. Corporations are, themselves, legal entities and have constitutional protections similar to individuals. Benefits to a corporation: shareholders of the corporation have limited liability for acts of the company. Shareholders have no liability for obligations or debts incurred by individual members, shareholder or employee. For S-Corp, taxes are assessed only on income distributed to shareholders, not company gross or net profit. Owners can take a distribution rather than a salary, reducing employment taxes. All other benefits of standard partnerships apply. Drawbacks to a corporation: corporations are expensive to create and maintain. Corporations are subject to double taxation. The corporation pays taxes on profits and shareholders pay income tax on any income, dividends, from the corporation. Corporations are subject to much greater government regulation and control than other types of businesses. Write a business plan. A business plan is a document that, among other things, details projections 3 to 5 years in the future regarding what route a company intends to take in order to earn revenue and have sustainable growth. We will cover business plans in detail at the end of this section. Obtain your Federal Employee Identification Number, FINE. Obtaining your FINE is not necessary if you are operating as a sole proprietorship without employees. Otherwise, obtain your FINE from the IRS here. Open company bank account. Source: Pixabay. Every business needs a checking account. This account will be used to process the daily costs associated with purchasing supplies, paying wages, and advertising. It isn't legally required that your business have a separate business checking account, but it is highly recommended. For small sole proprietorships, the owner may sometimes use their private checking account as a business account. This can lead to problems if the owner fails to track business expenses separately from personal and properly budget the account. For most businesses, a single checking account will be completely sufficient. However, larger companies could benefit from more. The general checking account is where you'll want to accept all business-related payments. If you charge an inspection fee or accept payment on a contract, then you'll need to place those fees into the business account. These fees must be placed directly into the business account as they're the business's money, not yours. One of the advantages of creating certain businesses such as an LLC is that the owner is protected from business liability. If the business is sued, the entity itself can lose all its money, but the owner will not lose the money in his or her personal account. If, however, you treat the LLC as if it were an extension of your personal affairs, as opposed to an entirely separate person, you risk losing this protection. Freely mixing business and personal money by placing them in the same account constitutes commingling of funds, that is, the mixing of client and business or personal funds. This commingling will be taken as evidence that the business isn't a true corporation and may open your personal account up to legal and financial liability. You want to make sure that you use good accounting practices when operating your business. Depending on the size and complexity of the business, you may wind up using very simple single-entry bookkeeping, which is what most people use on their private account. Single-entry bookkeeping simply means keeping track of all the money you put into the account and all of the money you take out of the account. It's important that you keep a running total while doing this. You should also reconcile your books every month. This involves taking all of the physical receipts and comparing them to the account books you have been keeping to make sure they match. You'll also want to compare this number to the actual amount in the bank account. If these three numbers don't match up, you'll want to locate the source of the error and fix it. Obtain financing. You should have already determined how your business will be financed when writing your business plan. If not, at this point, you will need to determine how you are going to pay for your business operations, self-funding versus outside financing. Self-funding options may include borrowing money from friends or family, or taking out a second mortgage. Outside funding takes either the form of equity investments, e.g. partnership agreements, or debt options, which are things like traditional loans, lines of credit, etc. Obtain licenses and permits. In the state of Michigan, you must have a contractor's license if you perform construction, repairs, or alterations in excess of $600 on any property other than your own and in which you live or plan to live. State licenses. Business license. Sales tax permit, if necessary. State licenses. In Michigan, there are two types of contractor's licenses available: residential builder and maintenance and alteration contractor. Business licenses. Your local city or county governments may both have licensing requirements as well. These are usually known as business licenses. You will need to check with your local county and city departments of licensing to find out what, if any, are their licensing requirements. Sales tax license. As a contractor, you do not have to collect or charge for sales tax. Any sales tax on materials is paid by you at the time of purchase, and you can recoup these costs by passing on these charges to your customer in your billing. Accounting systems. Consult with either an accountant or other companies performing the same type of work as you. Ask for recommendations on accounting procedures and software that will meet your needs. It is important that you have a good grasp of the fundamentals of accounting, even if you hire a professional accountant to manage your finances. Note, an overview of accounting principles and methods is given in detail below in the section titled Day-to-Day Management Concerns. You can also check out the following links to specific software * packages. QuickBooks Pro, by far the most popular and most user-friendly accounting software, includes a payroll option. http://quickbooks.intuit.com/pro. QuickBooks Online, same features as the desktop software but available online, includes a payroll option. http://quickbooks.intuit.com/online/irs. Sage 50, formerly Peachtree Accounting. Entry-level product that provides the basics of accounting at a low price. http://www.sage.com/sage-50-accounting. No endorsement or recommendation of any product is implied. AYPO is not affiliated with or endorsing Intuit or Sage. Record keeping. It is critical that your record-keeping system be in place before you begin operating your business. A record-keeping system is an important step in the accounting process. Record-keeping organizes information that supports the financial statements, tax returns, and analysis of business operations. It is important to keep records of all business transactions. Besides meeting regulatory requirements for business operations, accurate records are needed to assist in business decisions and planning, obtain financing, prepare estimates for bids, prepare payroll, control inventory, invoice customers, calculate taxes and withholdings, and prepare tax returns. In addition to the usual taxation issues, other legal reasons for record-keeping include contract disputes, lien claims, subcontractor or supplier claims, payroll disputes, obtain business insurance. There are many types of insurance for businesses, but they are usually packaged as general business insurance or a business owner's policy. This can cover everything from product liability to company vehicles. Develop a business identity. Order business cards, letterhead, and promotional materials for your business. A professionally created logo can make your business look knowledgeable and established. Systemize and organize. Prepare your business as if someone else were going to take it over and run it for you. This means implementing a functional method to process orders, pay bills, pay employees, pay taxes, maintain your permits, etc. Basically, try to make the operational aspect of the business as automated and efficient as possible so you can concentrate on growing your business. Hire employees. Once you have successfully defined and set up your business, it is time to hire staff and open to the public. Not every business will need to hire employees immediately, but if you plan to do so, this is the time. Business management, writing a business plan. Source, Max Pixel. A business plan is a document, generally projecting 3 to 5 years into the future, about the route a company intends to take to maintain and grow revenues. Getting started. A simple business plan can be no more than 1 page in length and is probably more than enough for most small businesses. Don't be fooled by its length. A simple but informed business plan can be a positive force throughout the life of your business, not just during the startup phase. Instead of detailing a simple business plan here, a great resource would be the book by Jim Horan called The One-Page Business Plan. This remarkable book provides everything you need to prepare a simple business plan step by step. No endorsement or recommendation of any product is implied. AYPO is not affiliated with or endorsing Jim Horan or Amazon. Outline of a basic plan. Source, Pixabay. However, if your company will be applying for business loans or lines of credit, a simple business plan may not be enough to satisfy the requirements of a bank or investors. Therefore, we present the following steps to generating a basic business plan. 1. Executive summary written last. 2. Company description. 3. Market analysis. 4. Strategy and implementation. 5. Management team. 6. Financial analysis. Step 0. Research. Know yourself and know your market. From these you will draw your company's mission statement. Ask yourself, why? Why do you want to deliver the service you do? Why do you want to go into business for yourself? Know your market, conduct market research. Market research is the process of gaining information about your market. Preferably, this is specific information about your target market and the key factors that influence their buying decisions. Market research does not have to be formal or conducted by a research company. It can be as simple as talking with homeowners in the neighborhood in which you wish to work. Open the M-Plans website for helpful information. Primary market research done by you, not information you found from someone else's research. Some examples are customer surveys of both existing and potential customers, focus groups, conversations with a small group of people, study competition, their technologies used, solutions to issues, and any particular niches that they fill well. Secondary market research. This is information others have acquired and already published. Access to this secondary market research data may be yours for the asking and cost you only an email, letter, phone call, or perhaps a nominal fee for copying and postage. Much of it is entirely free and available to search on the internet. Trade associations. Government information. Federal, state and local government reports. Small Business Administration (SBA). Small Business Development Center (SBDC). Service Corp of Retired Executives (SCORE). U.S. Bureau of Census. Educational resources. Chambers of Commerce. Market research firms. General market profiles. Specific information. Step 1: Mission Statement and Company Description. Your mission and vision for your company should drive all of your efforts in your business as a whole. Mission Statement. Source: Wikimedia. A mission statement is a brief description of a company's fundamental purpose. A mission statement answers the question, why do we exist? A good mission statement isn't just a slogan, it's an operations manual for your business. Mission statements are actually quite easy to create and only take about 3 steps. Describe what you do. Describe how you do it. Tell why you do it. 1. Describe what your company does. Short and sweet will get the job done. No need to be fancy here, just say it. Here's some examples. My company's purpose is to remodel homes, sell shoes, grow market vegetables. A general description of how your company operates is all that is needed here. For most people, this means looking at what their own core values are, and how those values are reflected in their business. Providing high quality. Providing excellent customer service. Protecting the environment. Promoting social equality. Encouraging creativity. With this description added, your sample mission statements could look like this. My company's purpose is to remodel homes efficiently and elegantly. Sell shoes of the highest quality. Grow market vegetables using organic farming practices. 2. Add the why. When you write a mission statement, be sure to describe the passion behind your business. If you aren't excited about your business, how can you expect anyone else to be? For some people, it helps to think back on why they started their business in the first place. Our sample mission statements now look like this. My company's purpose is to remodel homes efficiently and elegantly, so that customers will have the homes of their dreams in a reasonable period of time. Sell shoes of the highest quality so every customer can find a pair of shoes they actually love to wear. Grow market vegetables using organic farming practices to give people safe and healthy food choices. When you're finished, look at your draft mission statement and see if it says what you actually want it to say, or if there's a better way of saying it. Also be sure to replace the phrase, my company's purpose, with the name of your company. For example, at Interior Reflections, we remodel your living space into the home of your dreams quickly, smoothly, and without error. Vision Statement. Unlike your mission statement, which is targeted at everyone, your company, employees, customers, and clients, the vision statement is for you and the other members of your company only. A vision statement is essentially a picture of your company in the future. It is the framework for all your strategic planning. If you don't have a formal vision statement, don't panic. You already know, in your own mind, what you want your business to accomplish. 4 simple steps will help you bring it out into the open. Examine your mission statement. Dare to dream. Shape your vision statement. Commit to your vision statement. 1. Examine your mission statement. Your mission statement answers the question, why do we exist? 2. Dare to dream. Before you can travel to the moon, you have to first look up at the stars. Focus on the basics of your mission statement and ask yourself, where will my business be in 5 years? What will we have accomplished? 3. Shape your vision statement. Use the following formula to draft your vision statement. 5 years from now, your company name will underscore 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 by underscore 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 dot. For example, 5 years from now, Tiny Tots Diaper Service will be the top grossing diaper service in the area by consistently providing a reliable, affordable service for parents with small children. 4. Commit to your vision statement. Take action to make your vision statement come true. Use your vision statement as the basis of your business planning process. Keep your vision alive. Share it with potential partners and staff, if you have them. If you just tell it to people once, your vision statement will fade and disappear. Besides just talking about it, help keep your vision statement alive by printing it out and posting it on your desk, in your staff room, or anywhere else that you, your colleagues, or staff will see and be reminded of daily. Step 2. Set goals. Source: Flickr. Remember our old adage, if you don't know where you are going, wherever you end up will be just fine. For your business to succeed, you must set yourself goals to be reached. The difference between goals and objectives is really quite simple, but also quite significant. Goals are long-term projects, and your objectives are the stepping stones that get you there. Using our mythical company, Interior Reflections, as an example, and assuming that they are starting business in January 2019, one of our goals might be: by December 31, 2024, Interior Reflections will have gross profits in excess of $250,000 annually. A 5-year goal. Objectives that might help us reach that goal are: by March 30, 2019, have secured financing for equipment purchases. By June 30, 2019, have at least four $10,000 gross projects scheduled, in process or completed. By June 30, 2019, have company website and blogs fully operational. By June 30, 2019, have marketing materials distributed in all designated selections. By December 30, 2019, have at least eight $10,000 gross projects completed. By December 30, 2019, realize $50,000 in gross profit. Stay away from vague or generalized goals and objectives. A good method to follow is the creation of SMART goals and objectives. Specific, measurable, agreed upon, realistic, timed, i.e., has a target date. Specific. Avoid generalizing in your goals and objectives. Try to include as many of the following elements in each of your goals and objectives. Who is involved in the goal? What are you trying to accomplish? When will the goal be complete? Where will this goal take place? How will this goal be reached? Measurable. Ask yourself, how will I know when I've reached my goal? You will need to include some form of measurement in your goal so that you will know you have succeeded in reaching it, e.g., overall business growth of 6%. Agreed upon. When the going gets rough, it's easy to abandon your goals. For this reason, goals should be agreed upon by all those that will be involved in making them happen. Even if you're a sole proprietor with no employees, you may have to delegate some tasks to others. Make sure that they understand the importance of reaching your goals. You must also agree to yourself that the goal is important. It is a good idea to prioritize your goals and put some serious thought into whether or not individual goals are truly important to you. Realistic. One of the biggest mistakes you can make is to set yourself up for failure. The goals and objectives you set should be achievable within the time period you specified. It is an art to determine goals and objectives that stretch you just enough without becoming unrealistic. The more facts you are basing your goals and objectives on, the better you can predict real results. Timed. Always include a target date to achieve your goals and objectives. Then, note those dates in your calendar. It is important to include how much time you allocate to each goal. Too much time affects your overall performance, and not enough time sets you up for failure or poor quality. Work backwards. Start with long-term goals 1, 2 or even 3 years in the future. Once you have set your long-term goals, you will need to break those goals down into monthly, weekly, and daily mini-goals, aka objectives. Review, revise, re-implement. Schedule regular intervals throughout the year to review your goals and objectives and determine whether or not you are on track to achieving them. If you are ahead or behind schedule, determine what has caused the change, revise your plans accordingly, and re-implement for the remainder of the year. This is a vital step to staying on track. Just like a captain steering his ship, a business owner needs to check direction and adjust for unforeseen circumstances to get to the final destination. Goal setting and company planning should be done every year your business is operational. Not only does this keep you on track, but it also keeps you motivated to continue making strides towards becoming a better company. Step 3. Address your operational or implementation issues. Be specific. Include management responsibilities with dates and budgets. Make sure you can track results. Be certain to address management structure, product details and lifecycle, employee recruitment/hiring, management style, market analysis issues, advantages and challenges. Step 4. Complete your financial analysis. Remember how we briefly discussed obtaining financing? Let's review the difference between self-funding versus outside financing. Self-funding options may include borrowing money from friends or family or taking out a second mortgage. Outside funding takes either the form of equity investments, e.g. partnership agreements, or debt options, which are things like traditional loans, lines of credit, etc. Your financial analysis must take into account any market research you have done and should restate the information used in your operational sections above. At the very least, your financial analysis should include your plans for a funding stream and your projected profit and loss and cash flow tables. Step 5. Write your executive summary. Do this last. The executive summary is often considered the most important section of a business plan. This section briefly tells your reader what stage of operation your company is at, where you want to take it, and why your business idea will be successful. If you are seeking financing, the executive summary is also your first opportunity to grab a potential investor's interest. The executive summary should highlight the strengths of your overall plan and therefore be the last section you write. However, it usually appears first in your business plan document. Include the following elements. The mission statement. This explains what your business is all about. It should be between several sentences and a paragraph. Company information. Include a short statement that covers when your business was formed, the names of the founders and their roles, your number of employees, and your business locations. Your products/services. Briefly describe the products or services you provide. Financial information. If you are seeking financing, include any information about your current bank and investors. Summarize future plans. Explain where you would like to take your business. With the exception of the mission statement, all of the information in the executive summary should be covered in a concise fashion and kept to one page. The executive summary is the first part of your business plan many people will see, therefore, each word should count. For further information, you may also want to check out the following links. These sites provide a wealth of information on developing and writing a business plan. Open the B-Plan's website for tips, info, and training on writing a business plan. Open the Small Business Administration website for tips, info, and training on writing a business plan. Business management, general principles. Good business management will not guarantee success, but poor management skills will almost certainly ensure failure. 4 key principles of good business management. Appropriate and successful marketing. Ethical conduct. Good customer relations. Good employee relations. Marketing. Because successful marketing is so crucial to business success, marketing and sales will be covered in detail, separately, in Lesson 4. Ethics. Source, Pixabay. Definitions. Ethics, a standard of practicing honesty in all business dealings. Ethics in contracting should encompass every aspect of the business on a daily basis. Meeting or exceeding an ethical standard will have the result of long-term business growth and a positive, professional standing in the community. Remember, an ethical contractor is honest in advertising, assembles fair bids, has a professional attitude, and produces a quality product. Customer relations. Customers keep contractors in business. A good contractor is one who is able to communicate with the customer and does the job according to the contract. It is important to remember that when doing a job for a customer, all relationships should be kept on a professional level. Be friendly with customers, but do not make friends until the job is completed and paid for. Employee relations. Source: Pixabay. Individual concerns. Remember, your employees are your company's greatest asset. Employees who are happier with their work and their employers are more productive, more accurate, and more likely to attract business. Legal concerns. When you hire someone to perform work for you, you must adhere to laws and regulations that protect workers' rights. Unless you carefully comply with these laws, you could be in legal jeopardy. Be sure that your hiring practices are aligned with all laws pertaining to your industry. The Americans with Disability Act, ADA. One such law is the Americans with Disabilities Act, ADA, passed by the U.S. Congress in 1990. This was followed up with versions passed in every state that were patterned after the ADA. In general, the provisions only affect businesses with 15 or more employees, but its provisions are reasonable and should be honored even if the employer is not legally obliged to do so. Under the ADA, a person has a disability if he or she has a physical or mental impairment that substantially limits a major life activity. To be protected under the ADA, an individual must have a record of, or be regarded as having a substantial, as opposed to a minor, impairment. A substantial impairment is one that significantly limits or restricts a major life activity such as hearing, seeing, speaking, breathing, performing manual tasks, walking, caring for oneself, learning, or working. That does not mean a construction company must hire someone who is physically unable to do the job to avoid discrimination. An individual with a disability must also be qualified to perform the essential functions of the job with or without reasonable accommodation, in order to be protected by the ADA. This means that the applicant or employee must satisfy job requirements for educational background, employment experience, skills, licenses, and any other qualification standards that are job-related, and be able to perform those tasks that are essential to the job, with or without reasonable accommodation. The ADA does not interfere with your right to hire the best qualified applicant. Nor does the ADA impose any affirmative action obligations. The ADA simply prohibits you from discriminating against a qualified applicant or employee simply on the basis of his or her disability. Factors to consider in determining if a function is essential include whether the reason the position exists is to perform that function, the number of other employees available to perform the function or among whom the performance of the function can be distributed, and the degree of expertise or skill required to perform the function. The following are pieces of evidence that can be used to prove that a function is essential. Your judgment that the function is essential: a written job description prepared before advertising or interviewing a job, the actual work experience of present or past employees in the job, the average time spent performing the function, the consequences of not requiring that an employee perform the function. Reasonable accommodation is any change or adjustment to a job or work environment that permits a qualified applicant or employee with a disability to participate in the job application process, to perform the essential functions of a job, or to enjoy benefits and privileges of employment equal to those enjoyed by employees without disabilities. For example, reasonable accommodation may include acquiring or modifying equipment or devices, job restructuring, part-time or modified work schedules, reassignment to a vacant position, adjusting or modifying examinations, training materials, or policies, providing readers and interpreters, and making the workplace readily accessible to and usable by people with disabilities. Reasonable accommodation also must be made to enable an individual with a disability to participate in the application process, and to enjoy benefits and privileges of employment equal to those available to other employees. It is a violation of the ADA to fail to provide reasonable accommodation to the known physical or mental limitations of a qualified individual with a disability, unless to do so would impose an undue hardship on the operation of your business. Undue hardship means that the accommodation would require significant difficulty or expense. Overview. The day-to-day operation and management of your business goes far beyond managing a specific project and ensuring that it reaches completion successfully. The success of your business will rely, in large part, on the successful implementation of the following systems. Accounting systems. Record keeping. Accounting. Source: public domain pictures. The accounting top 10 lists. Top 10 do's of accounting. Top 10 don'ts of accounting. The top 10 do's of accounting. Learn basic accounting before you go into business. Go to school if necessary. Consult and retain an accountant familiar with your industry before you start. Determine what accounting software program works best for your business. In the beginning, do your own bookkeeping to gain knowledge of your accounting. Set up inventory policies and internal controls, including safeguards against dishonesty. Reconcile your bank account at least once a month when your bank statement is received. Maintain and update your cash flow control spreadsheet monthly. Plan to outsource your payroll and payroll reporting to a payroll service provider. Prepare financial statements at least monthly. Keep your business records separate from your personal records. The top 10 don'ts of accounting. Delegate the authority to sign checks to anyone. Use money withheld for payroll taxes or sales taxes for other purposes. Commingle personal assets with your business assets. Delegate cash flow projections, your lifeline to liquidity. Be optimistic in sales projections or conservative in expense projections. Overlook seeking advice from your accountant and lawyer on important financial matters. Pay an invoice without matching it to your purchase order. Delegate your relationship with your lending sources. Wait to establish credit sources until you have a need for financing. Rely on verbal agreements on any important matter, including purchases. Methods of accounting: the cash method. This method records income when cash is received and records expenses when paid. In this system, a sale on credit is not recorded until the payment is received, and invoices from suppliers are not recorded until bills are paid. Although simple to use, this system does not generally give the most accurate picture of the business's real financial position, as both income and expenses may not be represented. Methods of accounting: the accrual method. This method records income when it is earned, even if the payment is not received until later. Likewise, expenses are recorded when they are incurred, not when they are paid. A disadvantage to this system is that it requires more record keeping. Capturing or measuring revenue: completed contract method. Under this method, revenue, costs, and profits or losses are not recorded until the project is complete. This method is most often used for smaller or short-term contracts. Accounting system mechanics. Accounting systems use either single or double entry mechanisms. However, your accounting software will handle this aspect of the process. You do not need to focus attention on this unless you plan to hire a bookkeeper to maintain your records manually. Journals and ledgers. Journals and ledgers are used as components of an accounting system. Transactions are entered in the appropriate journal, usually on a daily basis. At the end of the month, the journal entries are added up and posted to a general ledger, which is summarized and used to prepare the financial statements. Journals and ledgers exist in both computerized and manual accounting systems. Some of the more commonly used journals include: Payroll journal contains employee wage information and monitors labor costs with data broken down by specific job types. Useful for future estimates. Cash disbursements journal contains a record of all checks written, including the amount and purpose. Cash receipts journal contains a record of all income and its source. General journal contains a record of all other financial transactions not captured elsewhere and makes corrections as necessary. Internal controls. Accounting controls are procedures you implement to safeguard your business's assets. These are not static guidelines, but the following are some of the more common controls used in business practice. Accounts payable control. Accounts receivable control. Payment by check control. Petty cash fund control. Accounts payable control. All bills should be paid from the business bank account. No check should be signed without verifying backup documentation such as an invoice or packing slip. The invoice should be marked paid to prevent double payment. Accounts receivable control. All monies received should be compared to the original invoice to verify accuracy. All monies should be deposited into the business bank account as soon as possible. Payment by check control. Except for small expenditures of petty cash, all business expenses should be paid by check, electronic transfer, or credit card in order to leave a traceable trail of the transaction. Checks should be pre-numbered and all payments should be approved by the owner or an appropriate corporate officer before payment is made. Petty cash fund control. Petty cash is a small amount of money kept on hand for payment of incidental expenses. One person should be in charge of the petty cash and must keep records of amounts spent. Financial statements. Financial statements are very useful tools for making business decisions. If the entries in your accounting system are correct and properly record your business transactions and operations, then your financial statements will accurately represent the financial condition of your business. The most common financial statements are an income statement, a balance sheet, a cash flow statement. Income statement. The income statement is sometimes referred to as the profit and loss statement or statement of operations. The income statement contains the following categories: revenues, direct costs, indirect costs, gross profit. Gross profit equals revenues minus costs, direct and indirect. General and administrative expenses. Other income/expenses. Tax expenses. Net profit. Net profit equals gross profit minus expenses. The balance sheet. Source: Flickr. The balance sheet shows the financial condition of the business by summarizing business assets, liabilities, and owner's equity as of a specific period in time. Another way to think of it is to see the balance sheet as a snapshot of financial condition, while the income statement is more like a video, showing activity over time. Cash flow statement. Cash flow refers to the money received by the contractor for work performed and money disbursed for expenses like office rent, materials, wages and benefits, or payments to subcontractors. The cash flow statement summarizes the cash inflows and outflows from operating, investing, and financing activities during a specific time period. Sales, accounts receivable. Most construction companies derive a portion of their revenue from short-term jobs where payments are received in full, either when the job is done or shortly thereafter. This source of revenue is similar to other industries and is easily entered into accounting ledgers. Many construction companies also derive all or part of their income from long-term jobs that can stretch out for months or longer. Sales numbers or accounts receivable often don't match up well with the time periods during which expenses for that job are incurred. Payments and expenses may be in different tax years. Best practices are for the companies to keep separate ledgers for short-term accounts receivable, generally paid promptly and in full, versus long-term accounts receivable, where the dates paid and amounts may fluctuate, and where the amount and timing of the final payment can be very hard to predict. In many cases, the long-term accounts receivable will be more of an estimate than an actual amount billed. Some discrepancies are to be expected between these anticipated long-term accounts receivable and the final disposition of the contract. Unless there is a repeated and flagrant pattern of misreporting accounts receivable in what appears to be an attempt to misrepresent the financial health of the company, some variation between estimated anticipated revenues and actual revenues is to be expected. Costs and expenses. Similar to accounts receivable, accounting of costs and expenses can be a challenge for a construction company. Since the contracts for which costs are incurred may overlap, strict accounting may not be easily accomplished. For example, what % of overhead costs for the main office should be expensed to an individual contract? Crews often go from one job to another, their hours can clearly be charged to an individual job, but the costs to buy and maintain equipment, durable supplies, etc., are not as clearly expensed. When it comes to comparing short-term and long-term income with the time frame when costs and expenses were incurred, it may be impossible to have strict accounting. Best efforts should be made to match the inflow and outflow of cash and to place them both in the same accounting or tax period. These challenges highlight the importance of effective project management, which we will explore later in the course. Financial ratios. A ratio is defined as a way to compare the relative size of two or more items. A financial ratio compares the relative size of selected accounting totals. The key word is selected. Think of it as similar to taking a soil sample. You don't dig up an entire field to test every pound of soil, but take carefully selected core samples. Similarly, a financial ratio is a small selection of accounting totals placed into a simple formula in order to derive their current relationship. As such, a financial ratio is any number of ways to slice the financial well-being of a company. There are dozens of financial ratios that can be used for specific purposes. Investors often rely on certain ratios they believe will guide them in buying and selling stocks and bonds, such as price/dividend, comparing how much a share of stock sells for divided by the dividends paid out, or price/earnings, comparing how much a stock costs divided by how the company's annual profit per share of stock. Many of these types of financial ratios are not helpful to a construction business, but some are very useful when trying to quickly assess whether the company is well positioned to weather a slow period, to accept a large job, to hire more people or downsize, etc. Financial ratios may also factor in when seeking loans or other forms of credit. Here are a few financial ratios to keep in mind, many more are listed here. Working capital ratio, also known as current ratio. Current assets and DIV, current liabilities. This is a simple way to determine a company's liquidity. All one needs to do is divide current assets by current liabilities. Current assets are generally taken from the balance sheet line item cash and cash equivalents, i.e. a ready source of cash or holding that can be converted to cash, such as a negotiable security. Current liabilities are those that are coming due for payment, including loan fees, premiums, payroll, and accounts payable. The name working capital comes from the fact that a company cannot allow its workers to work if current assets are insufficient to meet current liabilities. A ratio of 1, i.e., where current assets are equal to current liabilities, is considered a neutral rating, neither good nor bad. Any ratio below 1, i.e., where liabilities are greater than assets, portends trouble, more so, the lower it gets and the more entrenched it is. Any ratio above 1 is preferable. Quick assets ratio. Cash plus cash equivalents plus short-term investments plus current receivables, and DIV, current liabilities. The working capital ratio, discussed above, assumes business as usual. The quick assets ratio explores how the business might respond in a crisis. To find this ratio, any asset that can be converted to cash within 90 days is counted as a current asset. Accounts receivable are similarly counted. Any resource that is either in cash form or quickly able to turn into cash or that can be liquidated within 90 days is placed in the numerator. Current liabilities are any expenses that must be met within that same time period, including overhead, accounts payable, payroll, etc. This is sometimes referred to as the acid test ratio because it shows how the company can operate if pressed. Net worth to assets ratio. Non-current assets, fixed or capital, and DIV, all current and non-current assets, net worth. This ratio is often seen as key to a company's solvency. It measures how much is tied up in what may be termed non-current assets, such as a building, tools, as vehicles necessary to the company's operation, and any other aspect of the company that cannot easily be liquidated. This is compared to the same assets plus the more liquid or current assets. Unlike the working capital ratio and quick assets ratio, where a higher number is considered a sign of company health, a lower number is preferable here. In a sense, these more long-lasting assets are also a liability since they must be maintained. A billion-dollar factory that generates $1 million a year in sales is not as healthy as a $2 million factory that generates sales of $1 million a year. Traditionally, any ratio above 0.75 was considered unhealthy, but analysts now apply a more flexible barometer. Gross profit to sales ratio. Total sales, cost of goods sold, and DIV, total sales. This ratio is more typically used by a company that makes and/or retails reproducible products such as manufactured goods, food or baked goods, etc. How much a bakery makes per cookie, for example. It gives an idea of how profitable the company's basic operations are without taking into account the other costs of doing business. It may not seem relevant to a construction business, but the amount charged to customers relative to the cost of materials, including delivery and storage, gives a thumbnail for whether the basic business model makes sense. True investment yield. Gain from investment, cost of investment, and DIV, cost of investment, x rate of inflation. For those willing to invest in your company, or for you to judge your own benefit from investing in the company, one useful ratio compares return on investment to the true cost. The true cost is found by multiplying the amount of money tied up in the investment by the rate of inflation. By doing so, the degree to which the same amount of money has less spending power is reflected in the ratio. Profit margin. Net income and DIV, net sales. One way to see how well a business is doing is to determine what portion of its earnings can be retained. Retained earnings can be held as a cash or cash equivalent holding or paid out to owners and/or stockholders. For a construction business, that means comparing how much was spent in every line item to complete a project, net sales, up to when payment is received with the amount of the payment or payments. Overview. A record-keeping system is an important step in the accounting process. Record-keeping organizes information that supports the financial statements, tax returns, and analysis of business operations. Besides meeting regulatory requirements, accurate records are needed to assist in business decisions and planning, obtain financing, prepare estimates for bids, prepare payroll, control inventory, invoice customers, calculate taxes and withholdings, prepare tax returns, and address legal issues such as contract disputes, lien claims, subcontractor or supplier claims, payroll disputes. Mechanics and frequency of record keeping. A business's financial records and reports are generally prepared on a monthly basis. Filing of records and paper materials should be done, at a minimum, on a weekly basis. Filing is best done daily, however. Create separate filing categories or divisions, then organize records within these divisions. Basic examples include accounts payable, accounts receivable, contracts, employee records, inventory, typical records. Deciding what records need to be kept and how long to retain them depends on the nature of the business's work. Documents typically required in a construction business are permanent documents, some examples: articles of incorporation, articles of organization, partnership agreements, insurance policies, loan documents, credit applications, contracts, annual financial statements, copies of filed income tax returns, or other official documents. Other records to keep: time cards, customer/job files, supplier or vendor files, bank statements and canceled checks, customer billing, administrative expense records, job cost receipts. Record retention guidelines. The length of time a document should be kept depends on the action, expense, or event which the document records. For general business practice, records should be retained for up to 7 years. Records on assets like vehicles, equipment, buildings, or land must be kept for as long as the assets are owned. Records that support an item on a tax return should be retained until the limitations period for that tax return expires. Performance tracking. Performance tracking goes far beyond ensuring that a specific project is completed correctly and on time. Performance tracking refers to a continuous process of monitoring your business's progress towards the goals laid out in the business plan. Remember the cliché quoted in the section on business plans: if you don't know where you're going, wherever you end up will be good enough. In a similar manner, if you don't watch where you're going, you can't complain if you get lost. The difference between a successful business and one which goes under is the difference between one manager who keeps an eye on goals and objectives and progress towards reaching them, the successful business, and one who does not, the business which goes under. If you wish to be successful, you cannot allow yourself to become focused on only one project or one aspect of your business. You must constantly review all aspects of your business's function to succeed. Overview. Independent contractors and employees are not the same, and it's important to understand the difference. This distinction will affect how you withhold a variety of taxes, and misclassification of an individual may result in a number of costly legal consequences. An independent contractor operates under a business name, has his/her own employees, maintains a separate business checking account, advertises his/her business services, invoices for work done, has more than one client, has own tools and sets own hours, keeps business records. An employee performs duties dictated or controlled by others, is given training for work to be done, works for only one employer. Many small businesses rely on independent contractors for their staffing needs. There are many benefits to using contractors over hiring employees. Savings in labor costs, reduced liability, flexibility in hiring and firing, agency and regulatory compliance. If other people work for you, you may have responsibilities to both the state and federal governments. Note, if the business is a corporation, anyone who performs services for the corporation or receives remuneration, including any owners, is considered an employee. What follows is a list of those responsibilities. State and federal taxes. Employers must register with the Internal Revenue Service, 1-800-829-1040 for federal income tax withholding and Social Security taxes, and the Michigan Department of Treasury, Lansing, Michigan, 48922, telephone, 517-373-0888, for state income tax withholding for their employees. These taxes must be withheld from each employee's wages and paid to the appropriate taxing agency. Employers also must pay a portion of the Social Security tax for their employees. Some cities levy a city income tax. Contact the city treasurer's office for information. Withholding to the IRS is deposited on either a monthly or a biweekly basis. Here's a website with more details. State unemployment insurance. Employers must register with the Unemployment Insurance Agency, UIA, for unemployment taxes. Contact the Employer Customer Relations Office, 3024 W. Grand Boulevard, Suite 13-150, Detroit, Michigan, 48202, telephone, 1-800-638-3994 or 313-456-2180 for tax office/team support. Unemployment taxes are paid by the employer. No deduction is allowed from an employee's wages. Federal unemployment insurance. Employers must also pay federal unemployment taxes. Contact the Internal Revenue Service, 1-800-829-1040 for information. Unemployment taxes are paid by the employer. No deduction is allowed from any employee's wages. Workers' compensation. Most employers are required to provide workers' compensation coverage for their employees. A workers' compensation policy is purchased from a private insurance company. Contact the Workers' Compensation Agency, Box 30016, Lansing, Michigan, 48909, telephone, 517-322-1195 or 1-800-396-5041 for information. Health and safety information. Employers must comply with health and safety standards under federal and state Occupational Safety and Health Acts, OSHA, and Right to Know laws. Contact the Department of Energy, Labor and Economic Growth, Michigan Occupational Safety and Health Administration, P.O. Box 30643, Lansing, Michigan, 48909-8143 for MyOSHA Safety and Health Information, telephone, 517-322-1809. Immigration law compliance. All employers must verify the employment eligibility of all employees hired after November 6, 1986 by reviewing documents presented by employees and recording information on a verification form. Contact the U.S. Citizenship and Immigration Services at 1-800-357-2099 for questions on employment eligibility verification or visit their website at https://www.uscis.gov and go to Employer Information. For all other questions on immigration, contact the National Customer Service Center at 1-800-375-5283. Michigan Minimum Wage. Federal and state regulations set minimum wage and overtime standards. As of 2019, Michigan's minimum wage is $9.45 per hour. For information, contact the U.S. Department of Labor at 313-226-7447 or 616-456-2004, or the Michigan Department of Energy, Labor and Economic Growth, Wage and Hour Division, Box 30476, Lansing, Michigan, 48909, 7976, telephone, 517-284-7800. Federal Minimum Wage. As of 2018, the federal minimum wage is $7.25 per hour. For more information, contact U.S. Department of Labor, 231 W. Lafayette, Room 647, Detroit, Michigan, 48226, telephone, 313-226-7447 or 616-456-2004. Age restrictions. Employers hiring anyone under the age of 18 should be aware of restrictions on the type of work permitted, hours at work, and the need for a work permit. Contact Michigan Department of Energy, Labor and Economic Growth, Wage and Hour Division, Box 30476, Lansing, Michigan, 48909, 7976, telephone, 517-284-7800. Your rights under the USERRA, Uniformed Services Employment and Reemployment Rights Act. Source: U.S. Department of Labor. This poster is required by each employer and is designed to provide information on the rights and benefits under USERRA, Chapter 43, Employment and Reemployment Rights of Members of the Uniformed Services, of Title 38, Veterans Benefits, of the U.S. Code. Contact the U.S. Department of Labor, Veterans Employment and Training Service, 866-487-2365, or this poster can be viewed and printed for posting at https://www.dol.gov/sites/dolgovie/files/vets/legacy/files/usera_private.pdf. Equal Employment Opportunity. Contact U.S. Equal Employment Opportunity Commission, 1-800-669-3362, for federal forms or go to their website, https://www.eoc.gov. Contact Michigan Department of Civil Rights, 303 W. Kalamazoo, Lansing, Michigan, 48913, telephone, 517-335-3165 for state forms, or go to their website, https://www.michigan.gov/mdcr. Employee Polygraph Protection Act. Contact the U.S. Department of Labor, Wage and Hour Division, 231 W. Lafayette, Room 647, Detroit, Michigan, 48226, telephone, 313-226-7447 or 616-456-2004, or go to their website, https://www.dol.gov/whd. Michigan Employment Security Act Notice to Employees. Contact Unemployment Insurance Agency, 3024 W. Grand Boulevard, St. 13-150, Detroit, Michigan, 48202, telephone 1-800-638-3994 for having employer ID hashtag assigned, or go to their website, https://www.michigan.gov/uia. The problem. Recently, the state of Michigan created the Interagency Task Force on Employee Misclassification. The purpose of this task force is to investigate employers suspected of misclassifying its workers. Misclassification occurs when an employer treats a worker as an independent contractor when the worker should be classified as an employee. The motivation for employers to misclassify its employees as independent contractors is the fact employers can avoid having to withhold income taxes and other typical wage withholdings, as well as avoid having to pay unemployment insurance and workers' compensation insurance. To avoid these costs, the employer issues the Independent Contractor and IRS Form 1099 Miscellaneous, or, in some cases, pays the worker under the table. The independent contractor, in turn, is then responsible for paying all the typical withholding taxes. The problem is that the worker often intentionally fails to pay these taxes or is unaware of their obligation to pay these taxes. In either event, the state of Michigan loses tax revenue, payments into the unemployment insurance fund, and other money typically collected from wages paid to employees. In addition, the state of Michigan is concerned with the fact these workers who are misclassified suffer because they are not protected by employment laws, do not qualify for unemployment insurance benefits, and, in some cases, are not covered by the workers' compensation program if they are injured on the job. Employer's risk. Not only does the employer face being held responsible for payment of the taxes that should have been withheld from the employee's wages, the employer will likely be responsible for paying the employee's portion of these taxes as well. The amount of taxes the employer is required to pay often pales in comparison to the penalty, interest, and other remedies assessed by the state of Michigan and/or the Internal Revenue Service, IRS. Determining job title. Source: PX here. The main test used to determine whether or not an individual is an employee is related to the issue of control. If the individual is truly an independent contractor, then he or she operates under his or her own control. Control means whether or not the employer directs the schedule, work, and individual activities of an individual. If the individual is subject to the employer's control, then he or she is likely an employee. Although none of the following factors are definitive, any one of the following conditions might indicate that the independent contractor is actually an employee. The individual is hired to perform duties that are routinely being performed by employees working for the business. The individual will be supervised by an owner or employee of the business. The individual will work exclusively for the business. The individual will receive a consistent, periodic, e.g., daily, weekly, or monthly, payment regardless of the quality or quantity of work performed. The business will reimburse the individual for business or travel expenses. The individual will work on the business premises, use the business equipment, or be trained by the business. The individual works for the business for an extended period of time, or the individual doesn't maintain his or her own business. In 1972, the Michigan Court of Appeals set forth rules for the economic reality test for determining contractor versus employee status as: what liability, if any, does the employer incur in the event of the termination of the relationship at will? Is the work being performed an integral part of the employer's business which contributes to the accomplishment of a common objective? Is the position or job of such a nature that the worker primarily depends upon the emolument for payment of their living expenses? Does the worker furnish his/her own equipment and materials? Does the individual seeking employment hold him or herself out to the public as one ready and able to perform tasks of a given nature? Is the work or the undertaking in question customarily performed by an individual as an independent contractor? Control, although abandoned as an exclusive criterion upon which the relationship can be determined, is a factor to be considered, along with payment of wages, maintenance of discipline, and the right to engage or discharge employees. Weight should be given to those factors that will most favorably effectuate the objectives of the statute. These standards are expected to be applied with the boundaries of common sense. For example, while an auto mechanic may supply his/her own tools when working in a garage, the mechanic is almost certainly an employee. On the other hand, a concrete subcontractor pouring footings and a foundation, and operating with his/her own crew of employees would still be considered an independent contractor, even if it were necessary to use the equipment and tools of the general contractor. Michigan labor laws. Source: Pixabay. Once it is determined that your company has employees as opposed to independent contractors or subcontractors, the state laws that govern employer-employee relations take effect. Michigan does not have onerous requirements for employers, but does require policies to be carried out in a fair manner. See Michigan Department of Employment, Security and Workplace Safety, Wage and Hour Div FAQ. For example, Michigan employers are not required to provide employees with the following: vacation benefits, either paid or unpaid. If an employer chooses to provide such benefits, it must comply with its established policy or employment contract. An employer is required to pay accrued vacation to an employee upon separation from employment only if its policy or contract requires it. If the policy or contract does not provide for such payments or has conditions for denying a severance payment, the obligation is removed. An employer may cap the amount of vacation leave an employee may accrue over time and may have a use it or lose it policy requiring employees to use their leave by a set date or lose it, so long as employees have signed contracts or written statements agreeing to each of these policies. Sick leave, either paid or unpaid. If an employer chooses to provide sick leave benefits, it must comply with the terms of its established policy or employment contract. An employer would not be required to pay an employee for accrued sick leave upon separation from employment unless its policy or employment contract required it to do so. An employer in Michigan may be required to provide an employee unpaid sick leave in accordance with the Family and Medical Leave Act or other federal laws. Holiday leave. Not only is it not mandated, but an employer can oblige an employee to work on declared state and national holidays, nor is the employer required to pay any more than the normal hourly wage. If an employer chooses to provide either paid or unpaid holiday leave, it must comply with the terms of its established policy or employment contract. Jury duty leave. Although not required to pay an employee who has jury duty, the employer may not discharge, discipline, or threaten an employee for being summoned for jury duty, serving on a jury, or having served on a jury. Similarly, the employer cannot require the employee to work in lieu of jury duty or to work hours beyond normally scheduled hours to compensate for missing work for jury duty. Voting leave. Bereavement leave. It should be noted that, although Michigan does not require that an employer provide any of the above, many employers find that they can attract and retain the best workers when they offer liberal leave and benefit policies. Overtime pay, meals, and breaks. Source: Public Domain Pictures. Michigan labor laws require employers to pay employees overtime at a rate of 1.5 times their regular rate when they work more than 40 hours in a workweek. Note that this does not require overtime pay for more than 8 hours in a workday. These provisions mirror similar provisions in federal law, see below. Michigan labor laws require employers to provide employees under 18 with a 30-minute uninterrupted rest period if scheduled to work more than 5 continuous hours. Michigan does not require employers to provide breaks, including lunch breaks, for workers 18 or older. An employer who chooses to provide a meal, lunch, or break period must completely relieve employees of their work duties for the break period to be unpaid, otherwise, the employer must pay full wages for the break period. Health insurance. The opportunity or obligation to provide health insurance to employees is governed by federal statutes, not Michigan law. As you are no doubt aware, the Patient Protection and Affordable Care Act of 2010, more commonly known as the Affordable Care Act, the ACA, or Obamacare, has modified the responsibility employers have with regard to the provision of health insurance to employees. Businesses with 50 or more full-time or full-time equivalent/FTE employees that don't offer insurance, or offer coverage that doesn't meet certain minimum standards, may be subject to the payment. Learn more about the employer's shared responsibility payment from the IRS. In other words, if you do not have 50 FTE employees, the mandate to provide health insurance to employees does not apply. In order to encourage small employers to nevertheless provide employer-based coverage, the ACA also established the Small Business Health Options Program, SHOP, marketplace to help small employers offer affordable group insurance plans to their employees. Employers with 25 or fewer employees may qualify for subsidies through the SHOP marketplace to make coverage more affordable for smaller employers. Retirement, severance, and other benefits. Michigan employers are not required to provide employees with retirement benefits, welfare plans, severance pay, or other voluntary benefits. However, many employers choose to provide employees with such benefits in order to attract and retain the most qualified workers. If an employer does establish such plans, they are governed by a federal law called the Employee Retirement Income Security Act, ERISA. Under ERISA, employee benefit plans must comply with numerous and complex procedural requirements. Who is covered? Nearly all employers in Michigan are covered by workers' compensation. This includes both public and private employers. In fact, when talking about workers' compensation, it is easier to discuss the exceptions. There are a few classes of workers who are covered by federal laws and are not covered by the Workers' Disability Compensation Act of Michigan. Employees of the federal government, such as postal workers, employees at a Veterans Administration hospital, or members of the armed forces, are covered by federal laws. People who work on interstate railroads are covered by the Federal Employers' Liability Act. Seamen on navigable waters are covered by the Merchant Marine Act of 1920, and people loading and unloading vessels are covered by the Longshoremen's and Harbor Workers' Compensation Act. Virtually all other workers and employers are subject to Michigan's law. Certain small employers are exempt. However, if a private employer has 3 or more employees at any one time, or employs 1 or more workers for 35 or more hours per week for 13 or more weeks, the employer is subject to the Workers' Disability Compensation Act. What if a person is self-employed? As we discussed earlier in the Starting a New Business section, a business that is neither a partnership nor a corporation but is owned by one person is called a sole proprietorship. The owner of that business is self-employed. The employees of a sole proprietorship are covered by the Workers' Disability Compensation Act, but the sole proprietor, the person who owns the business, is self-employed. He or she is not an employee of anyone and accordingly is not covered by the Act. Are independent contractors exempt from the Workers' Disability Compensation Act? If one company hires another company to come in and do some work for it, the second company is ordinarily an independent contractor and not an employee of the first company. Sometimes, however, when a company hires one person to come in and perform a specific job, disputes can arise as to whether or not that person is an employee or an independent contractor. Section 161(1)(n) of the Act states that if the worker does not maintain a separate business, does not hold himself or herself out to and render service to the public, and does not employ other workers, the worker will be considered an employee. Must employers purchase workers' compensation insurance? The law requires that every employer subject to the Act must provide some way of assuring that it can pay benefits to its workers should they become injured. Most employers in Michigan provide this security by purchasing an insurance policy from a private insurance company. The insurance company then reports to the Workers' Compensation Agency, WCA, that it is providing coverage for that employer. Some employers, however, are self-insured. What is self-insurance? Some employers who are financially sound, and who usually have quite large companies, are self-insured. An employer can only be self-insured if it obtains permission from the WCA. The agency requires employers to demonstrate a very sound financial condition in order to be self-insured. Group self-insurance is another option that is available. Under these plans, several small employers which operate the same kind of business and belong to the same trade organization can band together to obtain approval for self-insurance as a group. Penalties. There are severe penalties for the failure of an employer to provide workers' compensation coverage. First of all, if a worker is injured, he or she may sue the employer for civil damages. If the employer was at fault for the injury, this might result in the payment of a great deal of money by the employer. Secondly, the Workers' Compensation Agency actively enforces the Workers' Disability Compensation Act. It has the authority to go into court and seek an order prohibiting the company from employing any persons in their business until such time as proper workers' compensation insurance coverage is obtained. Finally, the employer may be subject to a fine of $1,000 or imprisonment for not less than 30 days nor more than 6 months, or both. Each day for which the employer is uninsured is considered a separate offense. Safe working environment. As we will discuss in greater detail in this section on OSHA rules, regulations, and guidelines, every employer has a statutory responsibility to provide a workplace that is reasonably safe and free from threat of harm. Employers may not choose to ignore or postpone taking action on any safety-related issue of which they become aware. Failure to take prompt and immediate action can result in severe financial losses if an employee is injured as a result of a known danger. Environment free from harassment. Employees also have the right to a work environment that is free from any and all forms of harassment or discrimination. Harassment or discrimination in the workplace on the basis of religion, lack of religion, race, color, national origin, age, sex, height, weight, familial status, or marital status is expressly prohibited under the Ch1 Larson Civil Rights Act of 1976. A harassment-free work environment also includes the absence of any and all forms of sexual harassment. Americans with Disabilities Act, ADA. Source: Max Pixel. The Americans with Disabilities Act, ADA, is regulated by the Equal Employment Opportunity Commission of the U.S. Department of Labor. The ADA prohibits job discrimination based on disability. The Americans with Disability Act applies to all employers with 15 or more employees. An individual is considered to have a disability if there is a physical or mental impairment that substantially limits one or more major life activities, or a record of such impairment, or is regarded as having such impairment. For example, an individual who has epilepsy, HIV infection, or AIDS is covered under the ADA. An individual who has a minor, non-chronic condition such as a sprain or broken limb is not covered. A qualified individual with a disability is a person who meets the skill, experience, education, or other legitimate requirements of a position. The inability to perform marginal or incidental job functions is not considered a disqualification for employment. A written job description, prepared in advance of advertising or interviewing applicants for a job, is considered evidence of the essential functions of the job. Family Medical Leave Act, FMLA. The Family Medical Leave Act, more commonly known by its acronym, FMLA, allows eligible employees to take up to 12 workweeks of unpaid leave in any 12-month period. Specifically, employers of 50 or more employees are required to provide up to 12 weeks of job-protected, unpaid leave to employees who have worked for at least 12 months and for 1,250 hours when seriously ill, or to care for a new child, or a seriously ill child, spouse, or parent. FMLA protects an employee's job by allowing him or her to return to his or her job once the leave is over, except in some limited situations. The FMLA also provides that an employee's medical benefits remain at the same level while the employee is on leave, and that the employee must generally be allowed to return to the same or an equivalent position upon return from leave. Fair Labor Standards Act, FLSA. The Fair Labor Standards Act sets minimum wage and overtime requirements, including child labor standards. Basic requirements of the FLSA are as follows. Minimum wage. At the time of this writing, in 2025, the federal minimum wage is $7.25 per hour, while the Michigan minimum wage is $12.48 per hour. The Michigan minimum hourly wage has undergone scheduled increases from $9.65 an hour in 2020 to $9.87 an hour on January 1, 2022. This amount increased to $10.10 as of January 1, 2023 and then to $10.33 as of January 1, 2024. From January 1, 2025 through February 20, 2025, the minimum wage was $10.56. The minimum wage reached its current level, $12.48, on February 21, 2025. Current schedules would have the next increase to $13.87 an hour on February 21, 2026. It is further scheduled to increase in 2027, 2028, and 2029 with the amount ultimately rising to $14.97. Employees who are 16 or 17 years old may be paid at 85% of the current Michigan minimum wage. The employer must establish a workweek of 7 24-hour days, 168 hours. Overtime pay for all work over 40 hours within a workweek. Overtime pay for all work over 40 hours within a workweek must equal 1.5 times the employee's hourly rate. Employers may not use comp time in lieu of overtime pay. Detailed employment and pay records must be kept for every employee. Note, as of July 19, 2022, a Michigan Claims Court ruling requiring the $12 per hour minimum wage take effect by August 9, 2022, with the tipped wage rising from $3.75 to $9.60 per hour, along with a substantial expansion of paid sick leave, was being appealed by the Michigan Department of Labor and Economic Opportunity. It's unclear when or how this issue will be resolved. https://www.michigan.gov/leo/bureaus-agencies/br/wage-and-on-minimum-wage-and-paid-medical-leave?sc_site=Leo Employment of minors. Source: Wikimedia. Michigan's wage and hour law describes minors as all workers under 18 years of age, including volunteers and performing artists. Basic guidelines. A minor must be at least 14 years old for most occupations, unless exempt from the Youth Employment Standards Act. Minors may be employed in most jobs, except those considered hazardous. A work permit is required, unless the minor is exempt from the act or employed in corn detasseling. Minors may only work certain hours. Workers under May 18 not work more than 5 hours without a 30-minute uninterrupted break. Minors who are not covered by MI wage and hour law. 16 and 17-year-olds who have completed requirements for high school graduation. 17-year-olds who have passed the GED test. Emancipated minors, e.g., married minors. Students 14 years old and older working under a work-study contract between an employer and a school district that provides supervision. Domestic workers at private residences. Minors who sell, distribute, or offer for sale newspapers, magazines, and periodicals, and political or advertising material. Shoe shiners. Members of recognized youth organizations, Boy Scouts, Girl Scouts, 4-H, school clubs, etc. Minors working in businesses owned and operated by their parents. Workers who plant, cultivate, or harvest crops or raise livestock on farms. Minors employed in a school, academy, or college where the workers, ages 14 to 17, are students. Minors working in non-hazardous construction work performed under adult supervision as an unpaid volunteer for a non-profit charitable housing organization. Minors covered by the Act may not work in any occupations determined to be hazardous. Examples of hazardous work include, but are not limited to: work on construction sites, excavation sites, bridges, streets, or highways. Contact with hazardous substances, chemicals, explosives, or radioactive substances. Driving and working as an outside helper, pizza delivery, etc. Jobs in the logging and sawmill industry. Jobs using woodworking machinery. Brazing, welding, soldering, or heat treating for those less than 16 years of age. Slaughtering, butchering, cutting meat, or using meat slicers, cleavers, or boning knives. Occupations involving power-driven equipment, tools, saws, or machinery, bakery machines, paper product machines, and metal forming, punching, and shearing machines. Discrimination in employment prohibited. Just as employees are protected from harassment or discrimination in the workplace, so too are employers prohibited from discrimination in the hiring process. A. No individual may be denied employment or the opportunity for employment solely on the basis of religion, lack of religion, race, color, national origin, age, sex, height, weight, familial status, or marital status as set forth in the Elliott T. Larson Civil Rights Act of 1976. Michigan has debated many times over the years whether similar protections to the qualifying class of gender identity and sexual orientation should be added to Elliott Larson by amendment or be the subject of a standalone Civil Rights Act. On July 28, 2022, the Michigan Supreme Court ruled in Ch1, LLC. 5. Department of Civil Rights that discrimination on the basis of sexual orientation or gender identity necessarily constitutes discrimination because of sex, which effectively extended protections of Elliott Larson to LGBTQ Michiganders. Subsequent legislation known as the Crown Act, passed and signed in June 2023, prohibited employment discrimination on the basis of hairstyle and texture. Required new hire paperwork. Employers must maintain an employee file for each and every employee that includes, at a minimum, the following paperwork: an employment application, signed and dated by the employee. An original signed copy of the IRS Form W-4, Employees Withholding Allowance Certificate. An original signed copy of the Department of Homeland Security Form I-9, Employment Eligibility Verification. A photocopy of the documents provided for the Form I-9. A photocopy of the employee's Social Security card, even if other documentation was provided for the I-9. Payroll. As noted above, there are numerous accounting programs that include a payroll feature. For any contractor determined to take on this responsibility, use of such programs is a virtual necessity. Many contractors prefer, however, not to take on this task. Payroll is complicated for every industry. The construction trades add the complexities of irregular hours, rapid turnover, overlapping union and state rules on overtime, benefits, unemployment and workers' compensation insurance, etc. For many contractors, outsourcing this task to a payroll processing company saves sufficient time and eliminates a stressful and frustrating task so that the expense is worth it. Hiring a payroll specialist also relieves the contractor from potential liability if any calculations result in failure to pay fully, withhold sufficiently, etc. If the state or federal government detect a shortfall in withholding and payments, confessing a lack of expertise will not garner leniency. The business is expected to complete all payroll operations correctly and on schedule, or the company will be held liable. Note: payroll does not include payment to subcontractors. It includes only those persons directly employed by the business. Payroll taxes. Source: Pixabay. Taxes that are calculated on employees' earnings and deducted directly from the employee's check are called payroll taxes. All taxes to be paid by the contractor are held in escrow, not used for business purposes, until they are forwarded to the state or federal government. Taxes that the employer must withhold from employees' earnings are as follows: Federal income tax, State income tax, Federal Insurance Contribution Act, FICA, including Social Security tax, 6.2% of earnings up to $128,400. Medicare tax, 1.45% of all earnings. Social Security provides financial support in 3 potential circumstances: retirement, injury-induced disability, or congenital disability, i.e., a disability from birth. Additional amounts that must be paid based on employees' earnings, but which may not be deducted from the employee's wages, are the following: Social Security, FICA, taxes equivalent to those paid by the employee, 6.2%. Medicare taxes equivalent to those paid by the employee, 1.45%. Federal unemployment tax, FUTA, 6% of the first $7,000 of earnings. State unemployment tax. A self-employed person must pay both the individual and business portions of FICA contributions. In 2018, this self-employment tax was set at 15.3%, 12.4% for Social Security plus 2.9% for Medicare. Self-employed persons do not pay into unemployment insurance and are not qualified to receive its coverage. Depositing taxes. Deposit of taxes withheld must be made on either a monthly or semi-weekly schedule determined by the company's past year quarterly tax liability. The only exception applies if the total accumulated unpaid tax liability is $100,000 or more, in which case the entire amount must be deposited on the next business day. New employers. For tax purposes, new employers are assigned a monthly deposit schedule. If the accumulated tax liability is less than $2,500 during a quarter, payment is made with Federal Form 941, Employer's Quarterly Federal Tax Return. Social Security and Medicare taxes withheld, FICA, are deposited along with the income tax withheld. Each is reported separately. No Social Security tax is withheld on earnings in excess of $128,400 in 2018. There is no earnings limit on Medicare tax. Form W-4. Each newly hired employee must complete a Form W-4, Employees Withholding Allowance Certificate. Form W-4 tells the employer how many withholding allowances to use when deducting federal income tax from the employee's pay. After the employee completes and signs the Form W-4, it is kept in the company files. This form serves as verification that federal income tax is being withheld as the employee wishes. Form W-4 is not sent to the IRS. A Form W-2, wage and tax statement, must be furnished in duplicate to each employee as soon after December 31st as possible, but no later than January 31st. An employee leaving the company before year-end may request a Form W-2 and one must be provided within 30 days after the request. Form W-2 Wage and Tax Statement. Most employers use at least a 3-part form to accommodate state and local tax reporting. It is the responsibility of the company to file Copy A of Form W-2 with the Social Security Administration for employees showing the wages paid and taxes withheld for the year. Because Form W-2 is the only document used to transmit information on employees' Social Security and Medicare wages for the year, it is very important to prepare the forms correctly and in a timely manner. Form W-3. Form W-3 is a summary of all W-2s issued to employees. Form W-3 must be filed with the IRS by February 28 of the following year. Form 1099. If the company has independent contractors, a Form 1099 must be sent to the independent contractors by January 31 of the following year. Federal Unemployment Tax. Source: Shepherd AFB. Federal unemployment taxes are paid by the employer and are not deducted from the employee's paycheck. Federal unemployment tax, FUTA, is 6% of the first $7,000 earned by each employee during the year. FUTA is based on one of the following. Employee earns $1,500 or more in any calendar quarter. The company had one or more employees work any part of a day during 20 or more weeks during the last 12 months. Determination is made based on the number of weeks worked, not the wages earned. For example, if an employee worked part-time for the company over 20 or more weeks, the company is subject to paying FUTA regardless of whether the pay was under $1,500. If the company also pays state unemployment taxes, a credit may be taken for payments in the state fund up to a maximum of 5.4% of taxable wages. Form 940, Federal Unemployment Tax Return. An employer, other than a household or agricultural employer, files a federal unemployment tax return, Form 940, if either of the following situations applies. The company paid $1,500 or more in wages during any calendar quarter, or the company had at least one employee work for part of a day in 20 or more weeks. Form 940 Deposit Requirements. Form 940, Employer's Federal Unemployment Tax Return, is generally due by January 31. Although Form 940 covers a calendar year, deposit may have to be made before filing the tax return. If the contractor's FUTA tax liability exceeds $500, then FUTA taxes are deposited quarterly. Source: IRS website. Form 940 Deposit Requirements. If the FUTA tax liability is over $500 for any calendar quarter, it must be deposited through the Electronic Federal Tax Payment System, EFTPS, or using Form 8109, Federal Tax Deposit Coupon. If the total tax is more than $50, a record of quarterly federal unemployment tax liability must be completed. This part of the form shows the IRS whether the tax deposit has been made on time. There may be a penalty charged for late deposits, for mailing your payment to the IRS instead of depositing it, or for failing to use EFTPS when required. Record keeping. All federal records pertaining to employment taxes must be kept at least 4 years. In the event of an audit, these records must be kept at least 4 years after the resolution of the audit. Records that must be kept include, but are not limited to, the following: amounts and dates of all wages, annuities, sick pay, bonuses, and pension payments. Copies of all returns filed. Copies of both state and federal income tax withholding allowance certificates. Dates and amounts of all tax deposits or payments you made. Dates of employment of all employees. Employee copies of Form W-2 returned as undeliverable. Independent contractor/subcontractor copies of Form 1099 returned as undeliverable. Name, address, social security number, and occupation of all employees. Records of all fringe benefits provided, including validation. Records of any other payroll deductions authorized by the employee. The fair market value of any in-kind wages paid, and Employer Identification Number, EIN. Michigan Unemployment Insurance Tax. Generally, in the first 2 years of a business's liability, the unemployment tax rate is set by law at 2.7%. However, for employers in the construction industry, the peculiar circumstances of the industry are set differently. Construction business unemployment taxes for the first 2 years the business is in operation is set as that of the average employer in the construction industry, which is announced by Michigan's Unemployment Insurance Agency, UIA, early each year. In recent years, this construction rate has ranged from 6.8% to 8.1%. The rates in the third and fourth years of liability are partly based on the employer's own history of benefit charges and taxable payroll. This history is known as an employer's unemployment insurance experience. Beginning in the fifth year of liability, the tax rate is made up of 3 components which are computed separately and then added together to figure the yearly tax rate. The chargeable benefits component, the account building component, and the non-chargeable benefits component. The chargeable benefits component and the account building component are affected by the employer's payroll and the unemployment benefit charges to their account. Since these components reflect each company's experience, they are known as the experience components, and the entire taxing computation is known as an experience rating. Generally, employers with many former workers who have drawn unemployment benefits have higher tax rates, while employers with few former workers that drew benefits have lower tax rates. Note, UIA uses one of the most highly experience-rated systems in the country. This generally means that a Michigan employer's tax is more closely based on the actual benefit charges to its account and the size of payroll than employers in most other states. Business and Law for Michigan Residential Builder Licenses, Part 2. Source: Wikimedia. At the beginning of the course, we covered Article 24, the statute that governs residential builder licensing, enforcements, etc. There are, of course, other statutes that govern business practices in Michigan that also apply to residential builders. We will now briefly cover some of these statutes. Independent arbitration. On July 13, 2013, the Uniform Arbitration Act took effect in Michigan. The act is intended to encourage and facilitate the resolution of civil actions through arbitration, rather than a court case. Aside from disputes between employers and employees, one of the most common uses of independent arbitration is the resolution of disputes between contractors and customers. There are manifold grounds for disputes between a builder and a customer. First and foremost, since services are almost always delivered prior to receipt of payment, contractors may be forced to seek a legal remedy when payment is not received, not paid in full, or not paid in a timely manner. Similarly, a customer may seek legal remedy when the terms of payment are believed to be excessive, reflect unforeseen charges or cost overruns, or when there is a dispute as to whether the work done meets the standards of the contract. The state of Michigan recognized that legal redress through the courts imposes great costs to the community as well as to the litigants, often takes far longer, and has the potential for damages awarded by a jury that may bankrupt one or more parties. In order to streamline, make more predictable, and encourage arbitration as an alternative to a court case, the Uniform Arbitration Act lays out the procedures, rights, and responsibilities involved in arbitration. Briefly, the Act requires appropriate notice to all interested parties of the intent to seek resolution through arbitration. Note, it is common for arbitration in residential building cases to include several parties including subcontractors or more than one customer. The contracts and subcontracts for any residential building project may include a provision that requires all parties to seek a resolution of any disputes through arbitration. It should be noted that one or more parties may refuse to join in an arbitration hearing, in which case only a judge may bind all cases to the independent arbitration. Even after an arbitration is resolved, any party who continues to feel damaged may nevertheless seek legal redress through the courts. The hope and assumption is that such actions will be uncommon. Usually, a complaint is filed with the Michigan Bureau of Professional Licensing, BPL. If they believe the complaint has violated the occupational code, they may submit a formal complaint to a procedural process, and then assign the Michigan Administrative Hearing System, MAHS, to conduct an administrative hearing. At this hearing, a representative of the Bureau and the licensee may present testimony and evidence to support their sides. The original complainant is not a party to the proceedings, unless invited to testify. The MAHS then compiles a hearing report, which includes findings of fact and conclusions of law. The board makes a final decision or order using the hearing report. There are notable differences between a court hearing and independent arbitration. For one, the costs of hiring an arbitrator are borne by the participants. Note, although court costs are sometimes assessed as part of an adverse judgment, Americans do not routinely pay for the services of a judge or courtroom, but must pay for an arbitrator. Typically, an employer will pay the costs of arbitration. With a dispute between residential builders and customers, the decision as to who will pay for the arbitrator may be included in the contract or resolved through arbitration. Regardless of who pays for the arbitrator, or panel of arbitrators, the arbitrator does not work for that party but is independent and not beholden in any way to any party in the case. Attorneys are not required, neither may any side be denied being represented by an attorney. The award may or may not reflect the damages sought. Punitive damages may be added, at the discretion of the arbitrator. There may, however, be a limit on total potential damages to be awarded. Once a decision is made and damages awarded, the judgment is enforced by the court having jurisdiction in that location. In other words, an arbitration judgment has the same force of law as any levied by a court and is enforced with the same means and mechanisms. The Elliott-Larsen Civil Rights Act of 1976. Michigan has a proud, storied history with regards to civil rights. In 1885, long before the Great Migration brought many African Americans to Michigan, the state passed the Civil Rights Act, one of the first in the nation, which stated that all persons shall be entitled to full and equal accommodations, advantages, facilities, and privileges of inns, restaurants, eating houses, barbershops, public conveyances on land and water, theaters, and all other places of public accommodation and amusement. Within 5 years, in 1890, during a case, Ferguson v. Geese, about prejudice seating at a restaurant in Michigan, the Supreme Court of Michigan overturned a previous circuit court ruling that allowed the restaurant manager to segregate and refuse service at white-only tables by stating all citizens under the law have the same rights and privileges, and are entitled to the same immunities, it makes no difference whether white or colored. 6 years later, the U.S. Supreme Court, with Henry Brown from Michigan leading the majority, ruled that separate but equal was a violation of the Civil Rights Act, 64 years before the landmark Brown v. Board of Education came to the same conclusion for the nation as a whole. Not satisfied with this history nor the efficacy of the Federal Civil Rights Act of 1964, Michigan adopted the far-reaching Elliott-Larsen Civil Rights Act of 1976. The act guarantees Michiganders that the opportunity to obtain employment, housing, and other real estate, and the full and equal utilization of public accommodations, public service, and educational facilities without discrimination because of religion, race, color, national origin, age, sex, height, weight, familial status, or marital status as prohibited by this act, is recognized and declared to be a civil right. It should be noted that one of the concerns raised during debate over this act was on behalf of disabled persons in the state. In order to speak to these concerns, Michigan adopted companion legislation, the Persons with Disabilities Civil Rights Act of 1976. Similar to the Elliott-Larsen Act, this statute mandated that the opportunity to obtain employment, housing, and other real estate in full and equal utilization of public accommodations, public services, and educational facilities without discrimination because of a disability is guaranteed by this act and is a civil right. Michigan was again in the forefront in enacting these protections. The Federal Americans with Disabilities Act of 1990 both reinforced and extended these protections in the mandate for accommodations, where feasible, so as to remove barriers to employment, use of services, etc., on the part of disabled persons. Michigan has debated many times over the years whether similar protections to the qualifying class of gender identity and sexual orientation should be added to Elliott-Larsen by amendment or be the subject of a standalone Civil Rights Act. On July 28, 2022, the Michigan Supreme Court ruled in Ch1, LLC. 5. Department of Civil Rights that discrimination on the basis of sexual orientation or gender identity necessarily constitutes discrimination because of sex, which effectively extended protections of Elliott-Larsen to LGBTQ Michiganders. Subsequent legislation known as the Crown Act, passed and signed in June 2023, prohibited employment discrimination on the basis of hairstyle and texture. Michigan Barrier-Free Design Law. Source: Sketchport. Along with Michigan's forward-looking civil rights history, Michigan has been a leader in ensuring that those with impaired mobility are provided with access to the buildings of this state wherever possible. In 1966, 24 years before the Americans with Disabilities Act, Michigan enacted the Barrier-Free Design, Public Act 1 of 1966, intended to point the state towards having all buildings accessible and usable for all citizens. This includes elderly persons, wheelchair users, and persons with permanent or temporary conditions that reduce coordination or mobility or make walking difficult or insecure. Barrier-free design is also intended to ensure that persons with visual or hearing impairments will be able to use facilities safely. When barrier-free design was implemented as public policy in 1966 by Act 1, the law applied almost exclusively to government-owned buildings and facilities. In the mid-1970s, in response to the understandable desire for handicapped persons to live independently rather than in institutional settings, the law was amended to require barrier-free design in buildings where employment opportunities existed and where services to the public were available, e.g., schools, retail stores, restaurants, churches, hotels, etc. Michigan lawmakers provided some leeway with regard to retrofitting by only requiring accessibility standards when an existing building undergoes a change in use group, occupancy load, or an alteration. The change affects less than 50% of the existing floor area. Only the affected area and a barrier-free route to it, from and including the nearest entrance, must be barrier-free. If the change affects 50% or more of the existing floor area, the entire facility must become barrier-free. At the time this standard was enacted, Michigan lawmakers recognized potential hardship to building owners. To address this, the legislature also created the Barrier-Free Design Board, BFDB, and authorized it as the only entity in the state with the authority to grant exceptions, variances, to the barrier-free design requirements. Created in 1975, the BFDB consists of a 9-member citizen panel appointed by the governor with the advice and consent of the Senate. Act 1 specifically prohibits any person, local unit of government, state department, or agency other than the BFDB from granting an exception to the barrier-free design requirements. The BFDB can grant exceptions or variances from the barrier-free design requirements, require alternatives when exceptions are granted, and allow an exception for a stated time period or upon stated conditions. The board's final decision can be appealed to the Circuit Court of the county in which the project is located. Environmental regulations. Many of the regulations that govern environmental risks in construction are legislated at the federal level, in the Reduction of Lead in Drinking Water Act, Clean Air Act, etc. At the state level, the Michigan Department of Environment, Great Lakes, and Energy, EGLE, is tasked with enforcement of many of these federal statutes. For example, EGLE's National Emission Standards for Hazardous Air Pollutants, NESHAP, program governs safe removal of asbestos contamination of structures in Michigan. Home solicitation sales. Michigan, similar to every other state, enforces strict regulations on home solicitations. The statute governing this activity can be found here. In brief, it bans calling those on the do not call list, calling with mechanical or pre-recorded means, and enforces a time period until midnight of the third day after a sale obtained through a home solicitation for the customers to have a right to notify the seller of a desire to cancel the sale. It outlines the terms under which a refund must be provided or under which at least partial payment must be made by the customer. Source: Flickr. Physical location of building. As a builder in the state of Michigan, you may feel that all you need is a truck to carry tools and material, a license to practice your trade, a website to attract customers, and a post office box where they can mail the check. This mobile home office concept is not acceptable in Michigan. A licensee must have a physical location for their building, as follows. R 338.1531 Place of Business. Rule 31. 1. A builder or contractor shall maintain a place of business in this state, which is an actual, established physical location from which the builder or contractor conducts business and where applicable books and records are maintained. A post office box, secretarial service, mailbox rental, receiving service, resident agent address, or telephone answering service alone is not sufficient. 2. A builder or contractor shall display the license and the licenses of all salespersons in a conspicuous position in the builder's or contractor's place of business. Business name. The fundamental rule when choosing a name for your business is that it cannot create an impression in a typical customer of having an affiliation, connection, or capacity that it lacks. A name that would have a reasonable expectation of confusing or deceiving customers is not allowed. In other words, if a prominent contractor that operates in the vicinity is known as Builders Construction, naming your business Builders Construction Services would be viewed as deceptive, even if the name was not intended to be. If a similarly named business clearly does not operate in the same area and there is little reason to believe that an affiliation exists, similar names are permissible, particularly if the name is simply the surname of the owner. Lara maintains a website that can be used for background information regarding what can and cannot be used for a business name, which can be found here. Lara cautions that this is only a way to assist in choosing a name, but that final determination of whether a name is available for use is made during a formal review process. Proposed business names must be distinguishable upon the record from any active name reservations or name registrations. Lara specifies, a name is distinguishable on the record if it has a different sequence of letters or numbers. However, distinctions such as punctuation, and words like company, limited partnership, limited liability company and all of their abbreviations at the end of the name are not distinguishable. Lara also provides a restricted word list of words, abbreviations, and phrases that may be restricted or prohibited from use in a business name, along with an explanation for each and links to state and federal statutes, attorney general opinions, and bureau policy statements. Advertising. The Federal Trade Commission enforces truth in advertising laws. In addition, Michigan has strict rules on truth in advertising. It should be emphasized that advertising goes beyond display ads, television or radio ads, and flyers. A web page is considered advertising since it is a means for communicating goods and services offered. Indeed, any medium for attempting to encourage a potential customer to discuss or agree to a purchase is a form of advertising and is subject to the regulations intended to protect a consumer. With regard to licensed residential builders or M&A contractors, the following specifically applies. R 338.1532 Advertising. Rule 32. 1. Advertising shall not misrepresent material facts. 2. A licensee shall include the name, license number, and actual business address, as shown on the license, in all advertising. The use of a telephone or post office box number alone is prohibited. When sales of new homes are being made by a licensed builder, through a licensed real estate broker, advertisements may indicate the broker's name or both the names of the builder and broker. 3. A licensee shall not solicit any contract for home improvements by a promise to the purchaser or the prospective purchaser of a bonus, whether of merchandise or cash, which is contingent upon the purchasers or prospective purchasers using or displaying a dwelling to a third person or upon the licensees obtaining an order or orders for merchandise or service from a third person. 4. A licensee making or attempting to make sales through the use of displays, models or model installations, shall accurately portray the goods and services being offered so as to not mislead or deceive the public. Additionally, Section 445.903 contains an extensive yet still only a partial list of unfair or deceptive practices that can expose the tradesman to fines and other legal remedies. As stated in Section 455.903, unfair, unconscionable, or deceptive methods, acts, or practices in the conduct of trade or commerce are unlawful. In addition to direct misrepresentation, any advertisement that is likely to cause confusion or misunderstanding as to the nature, value, or specifications of goods or services is illegal. Some potential penalties for false advertising are laid out in Section 750.33, up to and including 1 year in jail and a $1,000 fine. Purchase and sales agreements. There is no part of a contracted job by a builder in Michigan that should be undertaken without a clear written agreement of the terms, the nature of the project and the amount to be charged. If there is a change to the contracted job at any point, either an addition, revision, or subtraction, that should also be documented. The following regulation applies. R 338.1533 Purchase and Sales Agreements. Rule 33. 1. All agreements and changes to the agreements between a builder, or contractor, and the customer shall be in writing and signed by the parties. Copies of all agreements and changes to agreements shall be in writing, and provided to the customer. 2. The builder or contractor shall make certain that the written agreements clearly state the terms of the transaction, including specifications, and when construction is involved, both plans and specifications, including cost, the type and amount of work to be done, and the type and quality of materials to be used. 3. If a purchase or sales agreement is for a new structure which is either substantially completed or in substantial conformance with a model, plans, and specifications need not be furnished if the structure is specifically identified or related to the model and any changes, additions to or subtractions from the model are specifically agreed to and noted in writing. Purchase and sales agreements for new construction, real estate license exemption. Where the new construction has been commissioned by a buyer/owner, it is more complex than a contract for a builder to work on a remodel, alteration, addition, or repair, but it shares many elements with those types of contracts. A buyer/owner who commissions new construction may or may not use the services of a real estate agent. The situation is somewhat different if the new construction is undertaken in hopes of subsequently finding a buyer. Similar rules apply to a purchase agreement for an existing home bought by the builder, remodeled, then resold. Michigan requires that anyone who engages in a purchase and sales agreement for new construction be a licensed real estate agent. There is an exemption to this requirement in Michigan's Article 25, the occupational code under which real estate brokers are licensed. 339.2503 Exemptions, Definition. This article shall not apply to an individual, partnership, association, or corporation, who as owner, sells or offers for sale a detached, single-family dwelling, duplex, triplex, or quadruplex, which has never been occupied and which was built by the individual, partnership, association, or corporation while licensed under Article 24. In other words, a residential builder or a contractor's license is required to offer a newly constructed residence for sale, but not a real estate license. The builder's license holder need not be the owner of the company offering the new construction for sale as long as the license holder is listed as a qualifying officer. The salesperson permitted to work for a residential builder or a contractor can also be involved in the sale but cannot do so on commission unless licensed as a real estate agent and cannot have such sales be their primary duty without a real estate license. Note that the exemption does not cover sales of a vacant lot either as a standalone sale or as part of the sale of a residence. The exemption can cover the sale of a vacant lot if the sale includes a contract to build a residence on the lot in the near future. Books and records, financial statements. When a residential builder or a contractor is given a commission for a project, a significant financial responsibility is assumed along with the responsibility for craftsmanship. Payment for permits and fees, material, subcontractors, bonds, insurance, employees, time delays, etc., as well as the need to qualify for loans all presume a financial capacity. In order to ensure that its licensees fulfill this obligation, the state of Michigan requires them to maintain financial documents that are current, accurate, and available for inspection. The following regulations apply. Are 338.1534 Books and Records. Rule 34. A builder or contractor shall keep and maintain a complete, accurate set of books and records which disclose the licensee's current financial condition. The books and records shall be open to inspection by the department or any person duly authorized by it for good and sufficient cause during regular business hours after reasonable notice and for stated reasons. Are 338.1535 Financial Statements. Rule 35. Upon notice by the department, a licensee shall submit within 30 days sworn financial statement showing the licensee's current financial status. The notice for a financial statement may be based upon an unsatisfied judgment, a lien filed against the licensee, or the department's reasonable belief that the licensee does not have the financial resources to meet contractual obligations. The department's notice shall be in writing and may be served personally on the licensee or by certified mail sent to the licensee's last known business address on file with the department. A request for an extension of time shall be in writing and may be granted for good and sufficient cause. Account for money received from customer. Related to the need for financial transparency required of licensees in order to demonstrate their ability to undertake a building contract in Michigan, a residential builder or a contractor must be able to account at all times for any and all monies paid by the customer and paid out for supplies, labor, subcontracts, etc. Two of the provisions of Article 24 Section 339.2411, Complaint, and Conduct subject to penalty, refer to the need to maintain such records. 2. A licensee or applicant who commits one or more of the following is subject to the penalties set forth in Article 6. B. Diversion of funds or property received for prosecution or completion of a specific construction project or operation, or for a specified purpose in the prosecution or completion of a construction project or operation, and the funds or property application or use for any other construction project or operation, obligation, or purposes. C. Failure to account for or remit money coming into the person's possession that belongs to others. For any larger project, maintaining a separate bank account for funds deposited and withdrawn for that project may be advisable. Under no circumstances should a personal account be used to deposit or pay out monies related to a contracted job. The commingling of personal funds and funds held in escrow for a customer is prima facie evidence of fraud. Similarly, the use of funds designated for payment to suppliers, subcontractors, or employees for other purposes is prima facie evidence of fraud, as per Section 570.153, Building Contract Fund, evidence of fraudulent detention or use. Section 3. The appropriation by a contractor, or any subcontractor, of any monies paid to him for building operations before the payment by him of all monies due or so to become due laborers, subcontractors, materialmen or others entitled to payment, shall be evidence of intent to defraud. Construction financing. There are three methods for financing construction: a construction loan, a mortgage loan, and direct payment from the owner. If the project is small enough, direct payment from the owner is common. In such cases, scrupulous accounting is necessary. Deposit into the business account or an account dedicated to that project is advisable. A receipt for any cash received is required. Any other in-person payment may be issued a receipt, but it's not required. With a larger project, a construction loan is more common. The builder may obtain or carry the loan. More often, the owner will arrange for the construction loan. Draws from the construction loan are predicated on contract terms and may be used as partial payment to the builder, payment for supplies or subcontractors, etc. They may be structured as either 1. Draws for specific costs incurred, or 2. Progress payments predicated on attaining specific interim goals, or less often as scheduled payments. A home improvement, second or third, mortgage is always obtained by the customer. Payments from such loans are done as if the payments were out of pocket. Finally, a mortgage may be obtained upon completion of a construction loan as a way to roll over the costs of construction from the short-term vehicle to a long-term one. Some lenders offer a one-step loan that automatically converts from a construction to a mortgage upon completion of the project. In other cases, the mortgage is obtained separately and used to retire the construction loan, which has already paid the contractor. Retainage. Michigan has no laws to govern the handling of retainage when a builder has a contract with a private party. There may be conditions on retainage specified in the contract with regard to what percentage of each partial payment may be retained and whether that amount must be placed in escrow as well as the ownership of any interest from the escrow account. With regard to public works, the maximum rate of retainage may not exceed 10% of each progress payment. If progress is satisfactory, the retainage may be reduced when 50% of the work is complete. Retained funds must be placed in an interest-bearing account and paid to the contractor as part of the final payment. However, a public agency need not deposit money in an interest-bearing account if the agency is to pay the contractor out of a specific state or federal grant and the contracting public agency has not yet received the grant money at the time of the retainage. When a delay in completion is the result of the contractor, all interest earned on retained funds becomes the property of the awarding entity. Michigan Business Tax, MBT, and Corporate Income Tax, CIT. The Michigan Business Tax, MBT, was signed into law by Governor Jennifer M. Granholm in 2007, replacing the single business tax. The MBT imposed a 4.95% business income tax and taxed modified gross receipts at the rate of 0.8%. Note, insurance companies and financial institutions had an alternate tax schedule. The MBT has since been replaced by the CIT. The MBT is only available to firms that qualify for certified credits that will lower the effective tax rate. Firms that qualify may opt for either the MBT with credits or the CIT. The Michigan Corporate Income Tax, CIT, was signed into law by Governor Rick Snyder on May 25, 2011. The CIT imposes a 6% corporate income tax on C corporations and taxpayers taxed as corporations federally. The CIT has one credit, the Small Business Alternative Credit, which offers an alternate tax rate of 1.8% of adjusted business income. There are no other credits, except those under the MBT election, addressed above. Insurance companies and financial institutions pay alternative taxes. Taxpayers with less than $350,000 in allocated or apportioned gross receipts and or less than or equal to $100 in annual liability are not required to file or pay the CIT. The gross receipts threshold does not apply to financial institutions or insurance companies. Do construction companies pay the CIT? As noted above, the CIT only applies to C corporations and taxpayers taxed as corporations federally. A vast majority of builders in Michigan are taxed, instead, as individuals. S corporations, LLCs, partnerships, and single-owner companies are almost always organized as pass-through businesses, where the profits and losses pass through to the individual or individuals who have financial responsibility for the company. Those profits and losses are then taxed through the returns filed by the individual or individuals. In other words, any contractor who, as proprietor of a construction business in the state that is not incorporated, files a profit and loss from business with the IRS is taxed as an individual and does not pay the CIT even if the business makes more in gross receipts than the $350,000 needed to trigger the CIT. It should be emphasized, however, that taxes, particularly business taxes, are very complex. The various credits, accounting methods, and documentation required to pay Michigan business taxes are far beyond the scope of this class to offer any guidance. The material presented here is simply an effort to introduce the topic and remind the student of the need to find the appropriate tax and/or accounting professionals to assist in the preparation of tax returns. Employer's responsibility to verify immigration status. Although the federal government has always required business owners to verify an employee's eligibility to work in the U.S., the Department of Homeland Security has made recent changes to how this is to be accomplished, and has begun strictly enforcing employment eligibility verification. Employers are now required to complete I-9 forms within 3 days after hiring an employee. The employee fills out basic information such as his or her name, date of birth, address, and social security number, and then the employer certifies that the employee has presented documentation confirming his or her right to work in the U.S. Fortunately, although the government will now enforce this requirement more stringently, it has also made complying with employment eligibility verification easier on employers. Employers can now store I-9 forms electronically, check the employment eligibility verification forms online, and learn about what to do if the employee's information does not match the information provided by the government. Most issues will be resolved within a week of submitting an online I-9, but in problematic cases, the employee will have to submit documentation and photographs to establish their identity and authorization to work in the U.S. If the employee cannot establish his or her identity and authorization to work in the U.S., then you must terminate his or her employment to avoid liability. Employers may also voluntarily use the E-Verify system accessible through www.uscis.gov to verify employment eligibility online. Insurance, bonds, and liens. Aside from workers' compensation insurance and vehicle insurance, Michigan does not require most businesses to carry any other coverage. As a prudent business owner in Michigan, there are a number of choices when it comes to either the required insurance coverage for workers' compensation and vehicles and the optional coverage for the business property, employees, etc. In addition, there are special insurance and bonding considerations that apply specifically to builders in Michigan. Insurance on company property. Michigan requires a physical address for a licensed residential builder or M and a contractor. Some builders will maintain a commercial office and/or workshop. Others will dedicate a portion of their home to business purposes. It is vital to check with your insurance agent to clarify what coverage may already exist for these locations and what might be excluded. If valuable equipment and supplies are stored at the location, existing policies may not cover damage or loss. Property insurance may not cover commercial activities out of the home. Clarify the coverage that exists and what additional riders or policies would best cover your business address. Liability insurance. Commercial general liability (CGL) insurance is the most common type of policy purchased by medium to large companies to protect their business from costs that may be incurred when an employee or business activity causes a claimed harm. CGL coverage is designed to reimburse an insured person or business for losses that result from being found liable of causing injury to another party or damage to another party's property. This kind of insurance coverage can protect the insured in the event of damages or injury that happen on the insured's property or on property under the control of the insured. The same policy can protect an insured in the event that the insured's commercial activities or finished work causes claimed damages or injuries. This coverage does not extend to any situation that would be covered by workers' compensation, nor does it cover damages related to mobile equipment that would be more properly covered by commercial vehicle insurance. Commercial liability insurance is not mandatory for businesses operating in Michigan. Michigan is a modified comparative negligence no-fault state. The plaintiff who is 51% or more at fault cannot recover damages. Non-economic damages for general personal injury are capped at $280,000. If a design defect causes death or permanent loss of a major bodily function, awards are capped at $500,000. The statute of limitations for personal injury is 3 years for negligent conduct and 2 years for intentional conduct. Product liability statute of limitations are 3 years, unless a product was in use for more than 10 years, in which case strict liability will not be the standard. Vehicle insurance. Source: Flickr. Similar to any privately owned automobile, any vehicle that uses public thoroughfares is required to carry insurance under Michigan law. A private car insurance policy will most likely be insufficient. Personal car insurance policies often exclude commercial activities from coverage in the event of an accident. Any vehicle used for commercial purposes most likely requires either a commercial vehicle policy or, for larger construction vehicles such as a cement mixer, etc., a commercial truck policy. All employees who use the vehicle for work activities are covered by the policy. The policy covers the vehicle, not the driver or operator. Your insurer will probably want an updated list of those employees provided access to the vehicles. Many builders will use the same vehicle for personal and commercial purposes. Check with your insurance agent as to whether the coverage is suitable to this dual use. In particular, the liability limits may be insufficient and the loss of use provisions are more complex, given that if the vehicle is unavailable, it may be difficult or impossible to accept or complete jobs. The full amount of the premium may also not be deductible as a business expense if the vehicle serves both personal and commercial purposes. No-fault auto insurance. Beginning in 1973, auto insurance claims are governed by Michigan's no-fault insurance law, one of the most comprehensive no-fault systems in the country. Basically, a no-fault system means that Michigan drivers involved in car accidents turn to their own insurance companies to pay claims and settle disputes, rather than filing a liability claim or lawsuit against another driver. In fact, Michigan's no-fault auto insurance laws prevent drivers from filing lawsuits against each other based on a car accident, except in a few very specific situations. When two Michigan-insured drivers got into a car accident, the no-fault laws told them to file a claim with their own insurance companies first. Every Michigan no-fault insurance policy was required to offer unlimited personal injury protection, or PIP, which pays most or all of the insured's injury-related costs. These include all of the medical care costs related to the accident, up to 85% of any wages lost due to the injury, for up to 3 years, and up to $20 per day for someone to take care of chores at home that the injured person can no longer do, like cooking, cleaning, childcare, and yard work. These benefits, however, are capped at a monthly total of $4,929 per month. Therefore, if your medical costs are particularly high or you had a high-paying job before your accident, your insurance company may not be required to pay every dime you've lost, if some of that money would push your monthly benefits above the $4,929 limit. No-fault insurance also covered up to $1 million in property damage. This included damage to a car, house, fence, or other personal or real property. A minimum policy also offered at least $10,000 in coverage for damage to property that is not located in Michigan. Finally, no-fault insurance covers residual liability, which refers to costs that come up when you're in an accident with a non-Michigan driver, an uninsured driver, or an accident in another state. It also offers coverage for costs if another driver sues you for an accident. As noted above, this minimal level of no-fault coverage was sometimes found to be insufficient to a contractor's business vehicles. July 1, 2020 No-Fault Insurance Reform. Although meant to lower auto insurance premiums by making lawsuits unnecessary, the result was the opposite in Michigan. Under the no-fault rules had some of the highest insurance rates in the country. In response, Governor Gretchen Whitmer signed a no-fault auto insurance reform bill May 30, 2019 that would become effective on July 1, 2020. The year of lag time was meant to give insurers and regulators time to fashion new policies, approve them, train staff, create forms, etc. The new rules do not repeal unlimited PIP coverage that was the basis of no-fault insurance. Instead, it requires insurers to offer 5 options, one of which was a continuation of the previous policies. If an insured didn't choose another option, the prior policies that had unlimited PIP and served as no-fault plans would be the default. As of July 1, 2020, motorists who are initiating, renewing, or revising a policy will have up to 5 options. Unlimited PIP coverage, a continuation of the prior plan. However, the law requires a 10% rate reduction for those who continue on this plan. $500,000 PIP coverage, slight savings for less coverage, a 20% required rate reduction. $250,000 PIP coverage, more savings with less covered, a 35% required rate reduction. $50,000 PIP coverage, only those who are on Medicaid qualify for this plan, a 45% required rate reduction. No PIP coverage, only those covered under Medicare Parts A and B or qualified healthcare coverage qualify. This obviously offers the highest savings. Because of the complexity and possible unforeseen outcomes, the law requires extensive customer education, forms that verify an informed choice, etc. Some analysts expect lawsuits to become more common and motorists may wish to organize their coverage to protect them against this. Business, accident, and life insurance. Smaller businesses have access to many of the same coverages as CGL through small business insurance. Obtaining this type of coverage is not required by Michigan law, but is prudent for most contractors in the state. Some policies may include coverage for business interruption. That does not mean a period during which no jobs are forthcoming, but an involuntary need to cease commercial operations for a time due to an accident, injury, or harmful event when operations would normally continue through that period. Coverage is limited and requires resolute efforts to resume operations. Accident insurance is available in Michigan for employers who wish to self-insure as opposed to purchasing workers' compensation insurance. The coverage provided through occupational accident insurance must meet the same standards as workers' compensation coverage. Life insurance is a benefit that was traditionally offered by many employers through group plans. It has become less common in recent decades but may be a benefit that attracts and retains some employees. Bonds. A surety bond is a promise by a bonding agency, purchased by the contractor, to provide limited payment to a consumer if a contractor fails to pay a valid claim. In a sense, it is insurance purchased by the contractor to insure the interests of other stakeholders. There are many possible stakeholders who can place claims against such a bond, or against the contractor if there is no bond. A property owner can file a claim against a contractor for a breach of contract, including failure to complete work, or for negligent or improper work. If Laura determines a contractor owes the property owner money, the contractor has to pay as ordered. If the contractor does not pay, the bonding company will cover the money owed up to the amount of the bond. The bonding company will then seek reimbursement from the contractor, depending on the nature of the claim and the agreement when the bond was purchased. Note that the bond doesn't protect the contractor, but his or her customer. Similarly, a supplier or subcontractor can make a claim against the surety bond. If a supplier or subcontractor files a mechanic's lien, also known as a construction lien, for claimed non-payment that would entail the property under construction, Michigan law allows for the mechanic's lien to be dismissed if a surety bond is posted equal to twice the value of the lien. This allows the lien to be lifted while the disputed payment can be adjudicated or resolved. Michigan requires that builders post a bond only for public works projects. Since a bond is posted for such projects, it is not permitted for subcontractors or suppliers to file a mechanic's lien on public works construction. Michigan does not require a bond to be posted to hold a residential builder's or and a contractor's license. Some builders may opt to back their business with a bond in order to be able to advertise as a licensed and bonded residential builder or and a contractor. It is illegal to advertise as bonded if no applicable bond is in force. Similarly, some private contracts may require that the contractor purchase a bond in order to protect the interests of the customer. Such agreements are entirely voluntary, but failure to abide by bonding requirements stipulated in a contract would open the builder to serious litigation and could result in a loss of license or other punishments. Title insurance. A builder rarely needs to be concerned with title insurance. When involved with new construction, however, the documentation that is needed to complete the project will include a title search to ensure that no other liens are posed against the property. Transfer of ownership, if involved in the construction, will also require a title search. Title insurance is a way to protect the new owner from a lien or claim against the title that was somehow not revealed during the title search. Since a builder may not receive full payment until a building is ready for occupancy and any outstanding liens can interfere with occupancy, it is in the builder's interest to be sure that title insurance is in place where a title search has been conducted. The Construction Lien Act. Pursuant to Michigan's Construction Lien Act of 1980, each contractor, subcontractor, supplier, or laborer who provides an improvement to real property has a construction lien upon the interest of the owner or lessee who contracted for the improvement to the real property. A construction lien acquired pursuant to this act shall not exceed the amount of the lien claimant's contract less payments made on the contract. The Act goes on to clarify how the claims for non-payment or inadequate payment from a supplier or subcontractor are to be filed, handled, and resolved so that the lien can be lifted. The Act also provides an option for the contractor to have suppliers or subcontractors sign a lien waiver when agreeing to provide the improvements to the property. When such waivers have been signed, the supplier or subcontractor no longer has an option for filing a construction lien and must resolve any disputes in another way.